if you're in the hospital, crawl to the stake, crawl there.
It's like Jesus going to the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumbs.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry. She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
Destroy.
I'm Megan Fox. Thank you. Cheers.
Good evening, everyone. I'm Megan Fox. Welcome back. This was an unplanned stream, but it has to happen because I have breaking news. I can't hear myself very well. I gotta check my volume. All right, there we go. Now I can. I had to turn my volume up. All right, so hello, all my good people on YouTube and on Rumble and on Facebook. All one of you watching me on Facebook. Thanks, Tina. It's always good to have you. And if you go to the YouTubes via the internets, there is a poll for you. And the poll says, I slap the like button like Judge Amy is about to be whacked. Mr. Fox slaps the TikTok leggings ass. And I slap it like I mean it. All right, just whatever you do, slap the like button, okay? And share the stream if you can. Your thumbs are not broken. I know you can do it. And if you're on Rumble, hit that little thumbs up and do share the stream because I don't have my little guy at Locals who's working right now because it's after hours. So he can't get the information to the editors. But anyway, my sister is about to join me. She is just getting home from work because she has been working nonstop. Now, you remember my sister, Stephanie Kimbrell. She is an appellate attorney, and she's going to be here with me to we're going to listen to arguments before the 8th Circuit Federal Appeals Court today for Judge Eighmy and removing his immunity. He has appealed it for the second time, I think. So he's already lost his immunity twice, by the way, twice. And this is in the case of the Rockett children. You guys might remember that I wrote about this case. I'm going to share this article with you so you can see it. Let's bring it up on the screen, and just in time. Stephanie.
Can you hear me?
I can hear you well, but you don't have headphones. You still don't have.
I don't. Listen.
Gosh darn it.
I just drove like a maniac.
Okay, listen.
From my office down. I literally just walked in the door.
Go get your headphones. I will wait.
Food. Oh my word.
I will wait. Go get the headphones.
Okay.
Go get them now.
Okay.
All right. When she comes back with her headphones, she can come back on. But not until then, because I am not going to put up with an echo for the entire time. She's so funny. What about toe thumbs hitting the like button? That might be difficult. You know, however you have to hit that like button, whether it's with your real thumbs or your toe thumbs, I don't really care. Just hit it. All right. Stephanie's so funny. How many times, if you guys have been watching this program for a while, you will know that I've been asking her to get headphones for how long now? Since the Johnny Depp trial. When was that? When was the Johnny Depp trial? How many months ago? That's how long I've been asking her to get headphones. Do you have your headphones? All right, plug them in. Okay.
Look,
Okay,
they're
great.
fancy.
Wait a minute. They look like they're broken. Are those going to work?
What? No, they have to work.
Plug it in now.
Wait a minute.
What?
I'm missing the little piece. I have to go get the piece. Hold on.
Okay.
I'm starving. I haven't had dinner.
Well,
This
get
is
a
my
snack.
roasted potato.
Get a snack. I'm just going to read my article while you're gone.
Okay.
I mean, oh my God. She's a mess. What a mess. All right. Here we go. Yeah, it's been close to a year where I've been telling her to get headphones because she can't get on this. Oh, this video's unavailable. What? They took it down? Oh, those sons of bees. You know what I mean. So now we don't even have video evidence of what this judge did. Gosh darn it. All right.
What?
Here she is.
We don't get to watch the video?
Oh, yeah. I've got I've got the arguments in front of the federal appeals court. That's what we're going to watch. It's not a video, it's audio. But I was going to show that what happened to your camera now. You plug in the headphones and the camera goes dead. Oh, now that sounds even worse. Okay, put them on.
Ooh.
Okay, great. I can hear you. Can you hear me?
I can hear you.
Oh my God, you sound so much better. Oh, you sound so much better and there's no echo. God bless it, Stephanie. This is what you need to have, our headphones.
Yeah, but see, my ears are bizarre and they're going to spend the whole night pushing these things out of my ears. That's what they do.
Whatever.
It's horrible. Like, my ears are weird. See?
Symphony Easy says, oh, way to go, Steph. You put no effort into those headphones. The chat is holding you accountable. It's been close to a year, Stephanie. Come on, Stephanie.
I bought these at the airport. And
Look at Light Giver. Says, I sound bossy. Tell him about it. Tell him how bossy I am.
Okay, you have no idea. This girl she's been bossing me since she was 2.
It's true. Tell them what I used to do to you.
What do you mean?
With the finger wagging.
Oh. Listen, Stephanie.
I mean it. I really mean it.
Oh, God.
Stephanie's the big sister. I'm the little sister, but I've been bossing since I was born. All right.
Yeah, so picture this. She's 2, okay? And a small 2. She was a teeny tiny little thing. I was 7, and she was putting that little bony finger in my face when I was 7 and she was 2.
I'm very sorry. Not really, though. Just get your headphones sorted out.
God, I hate these things.
Why did you buy them if they don't fit your ears?
You can't exactly open the box at the airport.
You need to get these. Look, these
and
go
shove
over
these horrible things.
These go over your ears, so you don't have to worry about that. They're much more comfortable. I'm going to send you some for your birthday. I didn't send you a gift. I didn't send you a birthday gift, so I'm sending you some headphones.
Okay.
For God's sake, what is the connection to your computer? Is it just a regular aux jack? Or are we on your phone?
We're on my phone, my iPhone.
Oh, that's complicated. All right. Well, we'll work it out. All right, let's get to it, shall we? We're going to read the background for what we're going to hear today. And I wrote about this on pjmedia.com. You can go there, find me, go to columnist, click on Megan Fox. You'll find all my stuff. Shocking lawsuit alleges Missouri family court judge unlawfully imprisoned, terrorized America's Got Talent stars. These are these 2 precious little children who were jailed by this judge.
That's insane.
In Missouri, the doorway to hell, by the way. If you were wondering where hell is, you can enter it through Missouri. Caden and Brooklyn Rockett were living an exciting and fun life before the family court got a hold of them and things took a dark turn. The Rockett children had a thriving career following in the footsteps of their father, Bart Rockett, a working magician and performer. They appeared on America's Got Talent and were stepping into acting when the family court nightmare began. Now, this used to be a TMZ video, I think, no, it is still there. Okay, never mind. It must be their video of their America's Got Talent thing. We don't need to see that. When Judge Eric Eimy in Taney Court, Missouri, got a hold of their custody case after the parents divorced, the children's desire to work in Hollywood and continue their blossoming careers without the interference of the state or their mother fell on deaf ears. In fact, the judge was so opposed to the children working in the entertainment industry, and by the entertainment industry, by the way, they worked in Branson, Missouri. So if you know anything about Branson, it's like family oriented. These are not the Hollywood people that you're thinking of. They were in a family show. They were in a family show with their dad, who's a magician.
Okay.
So it's not like these kids are not being pimped out in some Hollywood set somewhere like you're thinking of Hollywood. It's not the same thing at all. They're doing magic shows, they're getting tours, they're getting movie offers, like they're doing well.
Okay.
All right. So it fell on deaf ears. The judge was so opposed to the children working in the entertainment industry, and he determined to give them to their mother in Utah, and he threw them in jail twice to make that happen. A lawsuit against Judge Eimy filed on behalf of the children by their father describes the hell that they went through in Missouri courts. Now,
Wait a minute.
Mhm.
He threw the children
The children.
in jail?
The children, because they refused to go with their mother. Yep.
What a crazy
Oh, and Stephanie,
judge.
just wait. He left the bench, took off his robe, court was over, went out into the hallway, and escorted those children himself to the jail.
He needs a psych eval.
Oh, he needs to be in jail himself, and he's done it. He did it twice. So get this. This is from the complaint. Judge Eimy, acting in a police function without judicial process or immunity, personally jailed the children for approximately 1 hour. Judge Eimy later issued a pickup order for the children, and they were jailed for 2 nights in Louisiana. The first time the children were thrown in jail cells, they weren't even present in Judge Amy's courtroom. They were sitting in the hall, waiting for their parents to come out of court. It had been decided and agreed on that the children would live primarily with their mother in Utah and be with their father approximately half of the time and during all of their auditions and work-related events. The teens were strongly opposed to this plan and made it clear to their mother in the hallway that they would not be going with her. This led to a string of events that boggles the senses. Now, their dad left the building, by the way. So he was asked to go wait outside so she could talk to them. And this all happened while he was outside waiting in his car. So it's even worse because he had no idea this was going on.
How old were they?
I want to say 13 and 15.
That's a crazy judge, I'm telling you.
I think. I could be wrong about that, but I'll try and verify. The children then met with the court-appointed therapist, Dr. Baker, in a conference room adjacent to the courthouse lobby. The children told Dr. Baker that they did not want to live even part-time with their mother. Back in the courthouse, a conversation ensued between the children, Dr. Baker, and Judge Eimy. Judge Eimy was no longer in his judge's robes. The children explained to Judge Eimy why they did not want to go with their mother and why it was wrong. In Dr. Baker's presence, Judge Eimy then proceeded to lecture the children on the evils of Hollywood and the need to grow up normal, that is, without working as talent in the entertainment industry. Judge Eimy also told the children they needed to listen and to live with their mother in Utah. When the children began arguing the merits of their lifestyle and career choices, the judge allegedly lost his cool. At this point, Judge Eimy became visibly agitated, stated words to the effect of, "I will show you what I can do. I can put you in jail," and told the children to follow him. Judge Eimy then by himself and without Dr. Baker took the children down some stairs. They went down various hallways to a different room where there were doors to jail cells.
Yeah, he took them downstairs to lock up.
The jail cells appeared to be intended for the use of adult detainees or convicts, not children who were neither charged with a crime, being held in contempt, or found delinquent. 2 uniformed officers were by the jail cells, 1 male and 1 female. Judge Amy's face was red and he was breathing heavily. He angrily ordered the children to take off their shoes and socks and their jackets.
Ew.
The honorable judge even ordered one of the children to remove the religious bracelet that he had committed to wear at all times. Judge Eimy and the uniformed officers then led the children to jail cells. Judge Eimy ordered the uniformed officers to lock KR in one cell and BR in another. The male officer locked the children in the cells. Each cell had a small window in the door, and the children could not see or hear each other. The cells were cold and smelly. The children's bare feet were cold. BR stood on a raised bed mat because her feet were cold. While BR was standing on the raised bed mat, the male officer banged on the jail cell window and told her to get down. At least one of the two uniformed officers was thus watching the children by video camera. There were open toilets in each jail cell, but the children were afraid to use them because of the concern they were being watched. After about an hour, the judge returned. The children say he continued to threaten them. Will you go with your mother or do you want to go back in there? He said, according to the lawsuit.
Oh my God.
The children continued to say they would not go to Utah until the judge got creative with his threats. Judge Eighmy then stated words to the effect of, how would you like me to take you away from your parents and send you to live in the Missouri foster care system? The children, fearing further jail time and or foster care, stated they would comply with Judge Amy's directive to live with their mother in Utah.
Wait a minute. Did they have witnesses to him saying that?
Probably just those police officers.
Did they testify that he said that?
I don't know.
That's horrendous.
I don't know. Yeah, it is horrendous. It's really bad. Welcome, by the way, if you're just joining the stream, I've got breaking news in Missouri. We're finally going to get some justice against a bad judge. We are going over what he actually did. Please hit the like button and subscribe. If you're watching on Locals right now, meganfox.locals.com, there's a live chat there too as well. If you haven't joined me over there, it's so fun. We're doing laundry, we're doing cleaning and chatting. Today, you got to watch me clean up dog poop. It was fantastic. Who doesn't want to do that? Riveting stuff. It's almost as good as watching the paint dry on your office wall. Stephanie.
That was a good day.
It's a good stream. It really was. What are you eating, by the way? There's a lot of clattering going on. What are you eating?
So Alicia is taking a home ec class, and she made a roast pork loin with a cherry sauce.
Nice.
And roast potatoes and roast carrots. So it was all done for me when I walked in the door. I just had to heat it up in the microwave.
Oh, that's so great when the kids start learning how to cook. Well, I'm doing home ec on Locals. I'm doing cooking streams. We did freezer meals the other day. I made like 9 freezer meals on the Locals.
Missed that. I wanted to do that. Jack, what are you doing?
Well, you can still watch it back, you know. You can buy the ingredients and watch it and do it.
I need to.
All right, let's get back to this. What else did he do here? Wait, let me check in with Rumbles. Ooh, I missed a Rumble rant. Rants for headphones. Thank you, Raceland 9000. Sent a $2 Rumble rant for Stephanie's headphones.
I know you guys won't believe me, but these lame-o headphones at the airport were like $40.
Yeah, don't buy headphones that you don't know.
I was desperate.
For your ears.
Well, how can you know that? It's not like you can open the box and stick the things in your ears. That would be gross.
That's why you have to get, your ears are too small for any of those to work.
My ears are ridiculous.
Either buy kids ones or you get these kind that go over your head.
Look at, they keep on popping out. So stupid. Sorry, everyone. I know I look ridiculous, but
you don't look ridiculous. It's just, there's a lot of clanking going on over there.
What if I just take one of them out? Can you still hear me?
Oh yeah, I can still hear.
Does that mess up the microphone at all?
Nope.
Okay, then we're just going to do that. That's going to be less annoying for me.
All right, fine. It's the ice cubes that are very, very loud.
Sorry, well that's just, I'm not going to stop the ice cubes.
And now you're going to start crunching them? Oh, for crying out loud. All right, here we go. The lawsuit alleges that at no time did Judge Eighmy notify the guardian ad litem for the children that he intended to jail and threaten them, nor did he provide any party or attorney involved an opportunity to be heard. These actions violated the due process of the children, according to the lawsuit. But this judge wasn't done with these children yet. It became clear to their mother that living in Utah against their will was not going to work, and both parents wanted to change the order. You're going to love this, Stephanie. Judge Eighmy would not allow it.
There is no excuse for that.
Both parents wanted to change the order, and he said no.
The parents were both represented by lawyers, and they filed a consent decree.
Yep.
And he wouldn't. There's no excuse for that.
He signed the order for the children to live in Utah against all parties' wishes.
That's ridiculous.
In the spring of 2020, Bart Rockett took the children to live on his property in Louisiana during the lockdown. When it was time for their scheduled visit with their mother, the children refused to go. Courts generally acknowledge the difficulty parents have in forcing teenagers to go on visitation. The use of physical force to enforce compliance raises moral and legal questions about what constitutes abuse. In May, the mother filed in Judge Eigmy's court again, claiming that the father was withholding custody of the children from her, though he claims he had tried many times to get the children to comply. Judge Eighmy then ordered the family into his courtroom again. This time, the father sent his lawyer to enter a motion to disqualify the judge for bias and stayed home because he was in a different state. He was in
Yeah, how
Louisiana.
did the judge? Yeah.
Oh, yeah. Wait till you hear what he did.
At this point, why does the judge even have jurisdiction?
Have jurisdiction
over them?
because
How
the
long-
mother filed in his court, and
Yeah,
she
but
lived in
how long-
California. She lived in Utah.
How long had everybody been outside of the state of Missouri?
A long time.
It
should never have.
It
He
should have
should
been
never have had jurisdiction.
transferred.
It should have been transferred.
Okay, so then what happened?
The judge denied the motion to recuse himself from the case, of course, and instead issued a pickup order for the children. TMZ has the video of Louisiana police arresting the children and putting them in handcuffs.
Pause.
What?
When you say issued a pickup
We offer
order,
Hold
credit
on,
for
wait.
military-
What?
do you mean he signed a warrant for their arrest?
They call it a pickup order, but yes, it's essentially a court order. It's a warrant.
And then he
But they use
called
it for
the sheriff-
juveniles. They
Wait a
use
minute.
it.
Then
Yes,
he
they call the
called
sheriff in Louisiana.
Louisiana.
Yes.
And the sheriff in Louisiana said,
Actually, yep.
okay, I'll go
Uh-huh.
pick up those kids.
Yep. You want to see?
I'm sad to say.
I don't know what she's gonna do to us.
Completely honest, I am more scared of her than having some thing on my record.
You don't know that because you never have dealt with that.
I am pretty sure
You
that
don't
I understand
understand
that.
what she does. You don't understand what she's done.
We do not have a choice. This is nothing to argue about. This is nothing to discriminate about. You have to go with us. Let's go.
Very sorry.
I'm afraid of what she's gonna do to us.
Y'all have the right to remain silent. Anything you say can and will be used against you for a law. Your right to an attorney. You can't afford an attorney. State when brought to your charge. You understand your rights.
She's
I'm
a
asking you to
kid.
stand up and let's go, or you will be arrested.
He just read her rights. So are they under arrest or not? Because you
Clearly they are.
clearly you just read Miranda rights, so they're under arrest. And now he's still saying you either stand up or you're going to be arrested?
What
And how the
horrible-
hell does a child understand Miranda rights? Is that, Stephanie, is that
mm-mm.
legal?
I don't think so. If she had committed some kind of crime, then he would have a right to arrest her after reading her rights.
But
But
can
what
he say to
crime
a
has
child, do
she-
you understand these rights as I have read them to you?
I mean,
She can't answer that. She can't consent. She's not an adult.
This is cray cray.
It's great. Great.
Okay, so what happened
Wait,
next?
okay.
Go. You're under arrest.
That's what my phone went up on it.
Oh, oh.
You're handcuffed. I've asked you 100 times. Feel peaceful.
I love you guys.
That's disgusting.
Yeah.
Did
You've
the
never
family
wavered in your
sue-
dedication to country,
Come on,
community, and
stop.
fa-
Okay.
Did the family sue the officers as well as the judge?
You know, I'm actually not sure about that. I will have to double check with my sources and find out. I'm not aware of the lawsuit against those law enforcement. It's quite possible, but I don't know. The children were once again thrown in jail on Judge Eighmy's order. The handcuffs caused physical injuries to the children's wrists, particularly pain. The children received no medical treatment for those injuries. The children asserted to the deputies that the arrest was improper and wrong, but the deputies proceeded to make the arrests. The children were again denied their rights in due process. After the arrest and the reading of the Miranda rights, including the right to counsel, BR asked for a lawyer. The deputies responded that she was a child and that her parents would have to hire a lawyer. And the children had not been arrested, so they had no right to an attorney. He actually told her after he read her rights.
He
that
put
she-
her in handcuffs.
Yep, and then he told her, you have no right to an attorney because you're not under an arrest. Anyone watching the video, however, can plainly hear the officer read the children their rights and tell them they're being placed under arrest. The rest of the harrowing details of what the children went through are extensive. They were placed in separate vehicles. denied food, shuffled around at 4 a.m. to the juvenile detention center that was an hour away, and humiliated with an unnecessary strip search. On the arrival at Green Oaks, each child was strip searched and put in a cell.
On what
The children went to
basis?
sleep still without food, but after approximately an hour, the children were reawakened and subjected to a mental evaluation. Each child was held in solitary confinement cell for 2 days, with no visitors allowed. Although Bart tried to visit, there were cockroaches in the children's cells. The happy ending here is that Bart filed an appeal with the Missouri Supreme Court, which ruled in November that Eimy didn't have the jurisdiction over the case, so his orders were void. The children were released to their father, and they are safe in his sole custody now. A Louisiana family court judge stripped the mother of her rights after looking at the facts of the case and examining her part in creating this situation for her own children. The lawsuit is an interesting one to watch and will tell us if judicial immunity is inviolable in the state of Missouri. If anyone should lose judicial immunity, and many family court judges should, it's Judge Eric Eimy. His actions in this case cannot be covered up and should result in consequences. PJ Media reached out to Judge Eimy, but a clerk named Lisa hung up on us. She said she would not give him our message. You want to hear that?
Yes.
This is such a funny call. When does it start? Come on, Megan.
Okay. Is it regarding a dissolution, a family court matter?
Family court matter.
Okay, give me just a moment.
This is Lisa.
Hi, Lisa. My name's Megan Fox. I'm a reporter. I'm calling about a lawsuit that I have here filed against Judge Eimy in the case of the Rockett children and the jailing of the Rockett children. And I wondered if I could get Judge Eimy on the record with any comments about this lawsuit. I noticed he has not filed his response yet. I have a couple of questions. When's the response
Okay,
coming?
first of all, don't go any further because I'm just a court clerk. I'm in the family law division, and
You're a clerk for Judge Eimy, right?
Well, we all work for all the judges, so
yes,
I'm gonna.
No, she's not his law clerk. She's a court clerk.
And I can just send you to.
Well, no, I'm trying to get a hold of Judge Eimy, so I would like to
get
a message to him.
Okay, we don't give messages to the judges.
You don't give messages to judges when reporters call and say they want to comment for a news story. I'm writing a news story about a lawsuit that he's been named in, and this is his opportunity to speak to the press. If he wants to speak to the press, he can. If he doesn't want to speak to the press, that's okay too. But I have an obligation.
Ma'am, you're putting words in my mouth that are not. I'm not even saying to you.
I'm just trying to tell you. I have an obligation.
You know what?
I have an obligation to ask him. So you telling me you're not going to give a message to a judge? It's silly. Did you hang up on me? Oh my God.
Well, why didn't you call back to talk to like the public relations person for the court?
Oh, they don't have one. No, Stephanie, Missouri is the doorway to hell. Okay.
Okay.
That woman is the clerk for the judge. She says,
no.
Oh, no, she is though.
No, she's one of the court. Listen, there's an office of the clerk of the court that's full of clerks, like lots of clerks. All the clerks in there work for all the judges. They file papers, they stamp papers.
It's bullshit. She could not get a message to his clerk or to him. There's no way that she couldn't take a piece of paper and drop it up on the desk where. No, I don't believe it.
Listen, next time you have to get through to Chambers. In his chambers, he has an administrative assistant and a law clerk. The law clerk is actually a lawyer. That's who you need to talk to.
Well, guess what?
Not the court clerk.
You know darn well that court clerk could have walked a piece of paper over to his lawyer or whoever.
Well, she could have called
and just handed it to him.
She could have called the chambers and said, "Hey, there's a reporter who's going to do a story about you and they want to comment."
Right. Here's the message. Here's her number. Call her if you want to. Kenneth
Yeah.
Rosa, shout out to Kenneth Rosa for being here in the chat. Kenneth is the media spokesperson for the Fathers' Rights Movement in Missouri. And Kenneth says Missouri is the judicial family court highway to hell. Yes.
Oh my gosh,
that is
Kenneth,
true.
you must know all about this case then.
Yes, he does. We've worked together on a lot of these, and Kenneth is amazing. So anyway, you can go. I'm going to put this link in the chat so you guys. Oh, no, that was the wrong link. Going to put this link in the chat so you guys can save it for later. Clickety click. You can go and read the actual lawsuit that was chosen once to start wagging the finger, Megan. I was trying to wag it in that clerk's face, but it wasn't working. Make sure that you share that. Make sure that you share that. Oh yeah, I forgot to tell you guys about the horror that happened to me today. Why can't I put it in the Rumble chat? Okay, now I have to go put it in the locals chat. Okay, so right before I went on Steve Gosney's show tonight at 8 o'clock, because I promised him I would go on. Right
before on Steve's show?
I was on Steve Gosney's show just for a little bit.
Did he get his computer fixed?
Yes, and his book was saved.
Oh, good.
Yeah. So right before that, though, the dog had runny runs all over the dining room. Yeah,
Thank God for wood floors.
He had been whining at me, and I thought, and I had just let him out. So I'm like, just shut up already. Like, you don't need anything. Quit whining. Why are you whining?
Well, now
and
you know.
I made the mistake of ignoring it, and he had an accident in the dining room. I don't know what's wrong with him, but he's sick. Obviously, he's sick. And so anyway,
maybe you should give him some plain yogurt with no sugar in it and some plain rice.
I have that. All right. So the next article I wrote about this was in 2021. In December, Missouri judge loses bid for immunity for jailing America's Got Talent kids. So he filed to remove his judicial capacity, right? To remove immunity. And for those of you who don't know, immunity, judicial immunity, Stephanie, do you want to explain it?
Wait a minute. Okay, judicial immunity is the basic idea that you can't sue judges for the things they do as judges. If you don't like how they decide your case, for example, in a custody case, you don't appreciate it that a judge gave custody to another parent, you can't file a lawsuit against the judge and say, you should have given me custody. That was a stupid thing you did. They have immunity. They can't be sued for stuff that they do as judges, except in instances where they do something so completely outrageous and outside the bounds of their proper authority as a judge, in which case you can strip them of their immunity and sue them in certain circumstances.
So in December, Judge Douglas Harpool of the United States District Court ruled that the Rockett lawsuit will not be dismissed based on immunity. He wrote,
wait, pause. Which district court, what federal district court was this filed in?
Missouri.
In Missouri. Okay.
Yes. The allegations contained in the complaint are that the judge acted without jurisdiction and outside his judicial role when personally taking the children to jail, then subsequently ordering them picked up in Louisiana when there were no judicial proceedings pending that would allow for this judicial sanction. Whether plaintiff will be able to ultimately prevail is a question for another day. However, here, based on the allegations contained in the pleadings, plaintiff has stated a claim that judicial immunity may not apply, and certainly a claim that cannot be resolved by a motion to dismiss.
Nice.
The ruling by Harpool does a good job summarizing the allegations in the case, which we already went over. So we don't need to go over that up because we already read it. Okay, so that happened in December. Well, of course, they appealed. Now, here's something I need you to understand. Who do you think, Stephanie? I'll give you a guess. Who is defending Judge Eighmy? Any guesses?
Is it one of the horrible lawyers who was in that other terrible Missouri case you had where the little girl killed herself?
No. But do
One
you
of those
know
horrible,
when lawyers
corrupt
do you know
GALs?
when judges are in trouble and going to court, do you know who is obligated to defend them?
Obligated?
Obligated.
No.
The Attorney General of the state.
Oh.
For free, on you, taxpayer paid.
Oh, that's terrible.
The Attorney General, you thought the Attorney General of the state was the people's lawyer? Think again. The Attorney
know what?
General is the state's lawyer.
Okay. If the judge had been facing a judicial disabilities complaint, which, by the way, was he? Did they ever file a judicial disabilities complaint against him?
What is judicial disabilities complaint?
You can go to the Commission on Judicial Disabilities, which is run by other judges, and file a complaint.
Oh, I'm
Anyone
sure that
can.
was filed, and they throw it out. Everything
Or
in Missouri
ignore
that gets filed. Wait,
Okay.
no, I have an entire drawer full of these things. I have a whole thing. Like, wait, look. Do you see? This is just one of the
Yeah.
binders that I have
Yeah.
in my. Look how thick this is. This
Yeah,
is
what-
just one. This is just the St. Louis County victims. Every single one
Aw.
of these people in this binder, every single one put a professional complaint in about either judges or attorneys, and every single one got thrown right in the round bin. And
Oh.
they were told that they couldn't investigate it even. They were just, nope, you don't have a case.
Wow. So in
And I have
Maryland,
2 drawers full of those.
in Maryland, if somebody files a judicial disabilities complaint or a professional responsibility complaint against a lawyer, you have to hire your own lawyer to represent you. I mean, most definitely the AG is not going to show up. I cannot imagine. I've never filed one against a judge or a lawyer. Don't plan to, but I cannot imagine.
In other states, it's different. I've had people say they got responses in other states, not great responses, but at least investigations. Kenneth says, Office of Chief Judicial Counsel, that's what they're called, the OCJC. They are all in on it too. And they are. It's absolutely true.
Well, who funds them? Maybe you guys need to go to the
bar.
legislature.
The bar.
Maybe
Listen, the legislature knows. We have been to the legislature. They
Mhm.
know all about it. They know they can stop it, and they choose not to. And so I even got phone calls. Oh, I could tell you stories. I got phone calls from insiders at the Capitol telling me, "We're going to help you. We're going to help you do this. We're going to help you get
And
this
then they
done."
don't.
Oh no, they don't do anything.
Okay. What
It's
about
terrible.
Senator Hawley?
He's a U.S. senator. He's no
know,
help.
but
He's no
he
help.
does-
You
no.
need your local legislators. Senator Hawley is more interested in sound bites on television. He's not going to do jack for anybody. Sorry.
Well, have you told him about this?
No, I haven't even tried. Hawley, look, he's just like the rest of them. He wants his
think
time
you
in the
should-
spotlight.
I don't know. I think you should at least try because this is outrageous.
Kenneth, have you reached out to Hawley? He might be the one person we haven't reached out to. Did we talk to? Have you talked to Hawley? You let me know. All right, but let's get to why we're here this evening. Because now the Attorney General's office of Missouri, who are Republicans, by the way, I'm so disappointed in the Republicans of Missouri. They're so useless. They are so cowardly, spineless, and useless.
Mm.
And the Attorney General, by the way, who was the previous Attorney General when I was doing all this investigating, his name was Eric Schmidt, and we had a mutual friend. Eric Schmidt and I tell you people, I'm like 1 degree of separation from most of these people. I can send a little email and be like, hey, who knows the Attorney General of Missouri? And like within 5 minutes, someone will be like, oh yeah, I went to college with him. Or we were on a campaign together. Oh, great. So I get a friend of Eric Schmidt's to tell me he's going to contact him about this. And he sends me a text and he goes, yeah, he's interested in this. Yeah, I think you could call him. So I call him. This man avoids my call for like 6 months. He never called me back. And then I heard through the mutual contact, sorry, he's not interested.
Uh-huh.
Sorry, he's not
scared.
interested. Who knows? Scared, paid off. I don't know. Who knows? But there's a bunch of different things that could be happening. Anyway, the Attorney General now is somebody different. It's not Eric Schmidt. I don't know his name. I should probably look it up. Kenneth, who's the Attorney General now? Kenneth, do you want to pop in here? You're welcome to come in. Do you want me to send you a link? I'll send you a link if you want to pop in and listen to this with us. You're going to love this argument. You will absolutely love it. If you're not busy, let me know. I'll send you a link. He says Missouri's last 2 AGs are now our federal senators, Hawley and Schmidt. Oh, Schmidt became a senator? I haven't spoken to him on this issue, but I know both Josh and Eric. So perhaps I should visit both and figure out if they can help or not. If you visit Eric, ask him why he wasn't interested when I tried to call him a year and a half ago. Ask him why he sent me a message through a third party that said I'm not interested. Okay, So here's why we're here today. Just this afternoon, the Federal Appeals Court finally heard the case, and we get to hear the arguments that were made.
Which circuit?
8th Circuit.
Okay.
This is a 3-judge panel of appointed judges. Their names are, hold on, I have their name. Oh, and I have a statement, by the way, from Bart Rockett, who is who posted.
The dad.
He's the dad. He posted this on social media. Says, in United States federal court today with our attorneys, as we continue to set precedents, first kids to sue a sitting judge and have him stripped of his immunity, and seek justice for the injustice that Judge Eric Eighmy of Taney County, Missouri courts committed against Caden Bart Rockett and Brooklyn Nicole Rockett between 2018 and 2020. It was broadcast live and several media outlets were present, so I expect more stories in the days to come. As a reminder, we won the first round before the Missouri Supreme Court against this judge, where his illegal actions were undone. We won the second round before the United States federal court against this judge, where he was stripped of his immunity. And now we go into the third round. And by the way, the Attorney General did not have to appeal this case. They could have just sucked it up.
Yeah, let it go.
And let it go. But what are they doing? They're costing this family more money, more harm, more pain.
And costing the taxpayers.
Right. But Eighmy doesn't care because he's not paying for a dime of it. This isn't coming out of his pocket.
That's
and
horrendous.
by the way, he's still a sitting judge.
That's disgusting.
He is still on family court cases.
Oh, absolutely disgusting.
So he was stripped of his immunity. He is still on the bench deciding other cases in Taney County, Missouri appeals. I would like to thank our St. Louis-based attorneys, Hugh Eastwood and Bevis Schock, the National Institute of Justice in Washington, D.C., for sending attorneys to speak on our behalf, the National Police Accountability Project, and the National Association of the Counsel for Children for having their attorneys provide briefs to the court supporting us. Finally, thanks to Hollywood celebrities Mario Lopez for speaking out in support and sharing our story, as well as the celebrity couple who was asked to remain anonymous for their financial support, along with many friends who have contributed towards making this happen. In the future, we will have lots more to say publicly, but for now, cannot comment.
Meg, have you talked to any of the lawyers?
No, not yet. Anyone who is...
Let me just understand real quick procedurally. This is on appeal on the question of the motion to dismiss. So there's been no trial on the merits yet. We're still fighting.
We're still fighting the motion to dismiss. They have appealed and appealed. I mean, this is all the way to the circuit court, Stephanie. The next step is the Supreme Court. Are they going to appeal to the Supreme Court? You know what you people need to do? You people need to get on the phone tomorrow. That's what we're going to do. We're going to get on the phone tomorrow. We're going to call the Attorney General's office in Missouri and tell them, stand down. Stand down. Let this family have their day in court.
I mean, really, it's at what point does it become a total abuse of taxpayers' money?
It's already an abuse of taxpayers' money, and it's an abuse of this family who have already been abused. What the children?
In fact, you know what? If the Court of Appeals, if the 8th Circuit says no, the district court judge was right, he has no immunity for this. The case is not going to be dismissed on a motion to dismiss. Let it proceed. At that point, the AG should step down and say, "You're on your own, man. Get your own lawyer.
Get your own lawyer."
The courts have said you were not acting in your capacity, in your authority as a judge, and therefore you don't have a right to have me representing you. The people are paying for this, and we're going to stop. I mean,
I think Blurple Dragon's got it right. We're calling the AG tomorrow, and we're telling him due process for the Rockett children now. That's enough. It's enough. Stop it.
It's terrible.
What do you mean, you people?
Who said that?
Fedorovsky. All right. The rest of the statement says, anyone who is curious can easily Google the names involved and see the countless national and international news stories that have been done on this case. Notice I said national and international, as the local news media has completely ignored this happening in their own backyards. Now, Kenneth could tell us a lot about that. Ken, I didn't see it if you wanted to come in here or not. So I'm just going to send you a link anyway to your
so that means
to your phone.
the local press is totally corrupt.
Well, we've
because
known that. They wouldn't cover our stories either.
There's no excuse. There's
I
no
know.
excuse. There's no excuse for not covering that story. It's an international story, and the local press refuses to cover it.
Uh-huh. Yeah, because they're in on it. They have legal teams that work for their media companies that
That's
have
disgusting.
told them to shut up about all of the corruption that's going on in the legal system in St. Louis. They have told them, you know what they put on the news instead of my stories of court corruption? A snake on a can of baked beans in Georgia. That's not a lie. That happened. They reported at a Target that there was a snake on a can of baked beans. That was more important than my story of court corruption in St. Louis. That was more important than 31 judges recusing themselves from the bench because they colluded with guardians ad litem against a litigant in their own court.
That story was never anywhere in the local press.
Mm-mm.
That's insane. Talk about like press malpractice, malfeasance.
That's why I wrote 27 articles on it. There was no shortage of material from the lawyers to the judges to the media. It was like a constant onslaught of like insanity. All right, so let's get to the arguments because the arguments oh, there he is. Yes. Kenneth Rosa, media spokesperson for the Father's Rights Movement. I think we're talking your thumb. How are you, sir? I haven't seen you in so long.
It's been a while. How are you?
I'm excellent. I'm really good tonight. I'm in a good mood because this is going to go our way, Kenneth. It's going to go our way.
Hi, Kenneth.
How are you, ma'am?
Good.
Snakes are important.
Yeah,
Do you remember
snakes in
that?
Georgia are really
Rosa,
important.
do you remember that when we were waiting for our story to come up on the news that night and what came up was snakes on baked beans?
And there was a dog that fell into a pool and it got rescued.
Yes. And don't forget the tractor blessing. There was the cardinal himself came out to bless the tractors.
Mm-hmm. I do remember that.
Uh-huh.
That's pitiful.
It was bad. All right, so I'm going to pull up the arguments. You guys are going to love this.
Okay, wait. So are
what?
you telling me that the oral arguments in the Eighth Circuit were recorded live?
Uh-huh. And
What, were they
broadcast.
live?
Yes.
Do
But we're
all
not
the-
listening to it live, obviously. We're listening to it recorded.
Yeah, but do all the federal circuits do that? Because I didn't know
I don't
that
know.
they did.
I'm not sure, but we do have it here. In fact, I'm going to start playing it right now.
That Mr. Rockett cites Duba v. McIntyre when it discussed personal jurisdiction.
I got to go back to the beginning. They start shuffling
Do we get to
papers.
see
When
that,
after
or
the
just-
children
No.
and the father had not been complying with the terms of the settlement.
Okay, first comes the state. This is the Attorney General's guy. I don't know his
Case number
name.
21-3903 from Western Missouri, D. Bart Rockett et al. Versus the Honorable Eric Eimy.
Eimy. They call him Eimy.
Talent, when you're prepared, please proceed.
He's not prepared.
No.
He's throwing his files around. Okay, pause. Just pause.
Okay,
just
wait,
for a
wait,
minute.
wait. All right, I'm paused.
I just won an appeal a couple weeks ago, and I have to say that when I showed up for my oral argument at what was called the Court of Special Appeals and is now called the Appellate Court of Maryland, I was the first case on the docket. There was a list of like 5 cases. I was the first case on the docket. And so before I went in, I was talking to a guy who does appellate work in Maryland all the time. And he said to me, "Where are you on the docket?" And I said, "I'm the appellant in the first case." He goes, "Oh, okay. When they open the doors, just go in there, get all your stuff, put it on the podium, and stand at the podium before the judges take the bench. Don't even stand at trial table. Just stand at the podium so you're ready to go as soon as they call the case." And I said, "Okay." So I did.
Why? Because if they call it and then you're shuffling at the table, they're just going to get annoyed.
Well, or you look like you don't know what you're doing. So I thought, well, I'm going to listen to this guy. He's been doing appeals. He does appeals constantly. He's down here all the time. I'm going to just do what he said. So I did. I got my big binders out. I had all my stuff open and just set up on the podium, and I didn't even go to counsel table. I mean, Ed was sitting at counsel table because he came with me, but I was doing the argument. So I just decided I'm going to set myself up and get my stuff all ready to go. And literally they came out. I was standing there. They said, good morning. They called court. They said, okay, we're here for blah, blah, called my case, the case number. And they said, counsel, please proceed when you're ready. And like 2 seconds later, I was starting.
You were going.
Good morning, Your Honors.
Not like this guy.
I'm just saying. Oh,
look, he's still shuffling.
Wait, and I won.
Oh, good for you. Look, we're 40 seconds in. He's still shuffling.
See, I wasn't doing that.
And now he's clearing his throat.
I didn't do that either.
Good morning, Your Honors. May it please the court. Michael Talent. I represent Judge Eighmy in this
Michael Talent. His name. All right, now we have his name. I'm going to find his picture.
Judicial immunity appeal. This case stems.
What?
Is he the actual AG, or is he just somebody from the office?
He's like one of his flying monkeys.
One of the deputies.
Yeah.
Okay.
Michael Talent, Missouri lawyer, attorney general. Okay, let's see. Missouri general. What's his Talon? Did he say Talon? Hold on.
Yeah, Talon.
Talon. Does that sound familiar to
Comes
you?
from an underlying custody dispute in Taney County Circuit Court in Missouri and involves 2 acts by Judge Eimy. Each act implicates a different part of the judicial immunity analysis. The first act, and therefore the first part of the analysis, is whether Judge Eimy engaged in a judicial act when in October 2019, he escorted the children, who are the plaintiffs here represented by their father, down to the detention holding area or detention area of the courthouse in order.
When he escorted
area.
When he escorted the children down to he didn't want to say it.
He didn't want to say lockup.
He didn't want to say it.
Officers to detain them for an hour because the children had refused to comply with the custody agreement that the parents had reached that day and that Judge Eimy had approved, and that all agreed on the record was in the children's best interest. The second question in a subsequent proceeding in the same custody dispute is whether Judge Eimy acted in the clear absence of jurisdiction when, after the children and the father had not been complying with the terms of the settlement agreement, the mother filed a contempt motion in Taney County Circuit Court, and after the father and the children didn't show up, Judge Eimy issued a pickup order that resulted in the children being detained in Louisiana by Louisiana deputies. The first is a judicial act under square precedent from the Supreme Court and this court, and the second was an act done under the subject matter jurisdiction of Judge Eimy, and so therefore was not done in the clear absence of jurisdiction.
Subject matter jurisdiction. Those of you who were with me with the Darrell Brooks trial, remember that. Subject matter jurisdiction.
And he is entitled to judicial immunity for both acts. Turning first to the October 2019 detention, the question there is whether what Judge Eimy did was a judicial act. This is a functional analysis. It looks first to whether the act relates to an action or a function normally performed by a judge, is a language used in, for example, Stump v. Sparkman and Justice Network. Judge Eimy in his briefs provide 3 examples of normal judicial functions that relate to the act he did here. The kind of high-level question of the high-level act we're looking at here is whether it's a normal judicial function for a judge to order individuals who are defying or thwarting the efficacy of a judicial order.
It's a normal function of the judiciary. But do you notice that he's saying that they flouted a judicial order? But for one, they weren't even under order because they were the children. They're not a party to the case. So how do you get a part? The children are not technically under the order. It's the parents, right? They had agreed to.
The parents are ordered to do, whatever. But I didn't get that from your recitation of the facts. It was by consent. The first deal.
Yeah, they had agreed. They had agreed to it.
Do people understand what the Stump v. Sparkman case was about? That was about a female being judicially sterilized, and she sued the judge later, and the courts came back and said that even though he basically was in the wrong because he was a judge, even though he sterilized a human being against her will,
Wait a minute,
he had judicial immunity.
You mean he ordered that she be sterilized?
Yeah, he
Correct.
Didn't, he didn't do
In-
the
in-
sterilization
in-
himself. Although Judge
Stop-
Eimy probably would have taken that tack. He's like,
Okay.
feet up in the stirrups, please.
Stump v. Sparkman is a case where a judge ordered a young lady that could not consent at the time because she was underage to be sterilized. And then later in life, she sued him because her and her current husband couldn't have children. And the courts came back and said, well, yeah, he probably shouldn't have done that, but he was a judicial judge at the time. So
That's
he's
horrendous.
immune.
Was that a state court decision or a federal decision?
That is a SCOTUS decision. Stump v. Sparkman.
Good
SCOTUS,
Lord.
Supreme Court?
Yeah.
Yes, ma'am.
They protect their own. Listen.
Hold it. Wait.
They
in
protect
what year?
their
What year
own.
was that?
Well, I'll look it
issued?
up. Hold on.
Stump
I
v.
bet it was the
Sparkman. I want to say it was in the 70s. Yes, like 76,
That's when
78, somewhere
they were-
around there.
My gosh.
1978. That's when they were going hog wild with the sterilization as
So-
an answer to wild girls.
So if
That's
people actually
horrendous.
understood where judicial immunity come from, especially in this age of femininity and women power, like there would be no judicial immunity. You got judicial immunity from sterilizing a woman against her will.
That's
Wow.
disgusting.
That is disgusting. See, this is why you're here, Kenneth. You bring the facts, and we love you for it.
Was there an order in place? As I understood, this was a consensual agreement between the parents. And there really was no order in place.
The judge had approved the order that day, and that's in the record. Now, it wasn't, I think Mr. Rockett quibbles about whether it was denominated a final judgment under Missouri law, but everyone, I think, agrees that was the operative complaint and the operative kind of custody arrangement entered in court at that time, and everyone had agreed
Were
on
the
the record.
children parties to this agreement?
The parents are parties to a custody agreement. The children are kind of in Missouri,
Victims.
they're subject to the in rem jurisdiction of the court. So the children were there, and as part of the proceeding, they weren't parties to the proceeding, as it were.
But is it
were.
ordinary for judges to issue I assume the judge considered this contempt? What is the judge's authority and basis for seizing the children?
We point to, so Judge Eimy does point to the contempt procedure. It's a normal function, a normal authority of Missouri judges to be able to hold individuals.
So is that your position, is that this was a contempt action?
He doesn't want to say
Judge
yet.
Eimy didn't denominate what authority he
Pause.
was operating.
He's trying to make the argument that the kids committed a direct contempt in the presence of the judge, for which the judge could do an instantaneous order and throw the kids in jail.
But he didn't.
That's insane. It's insane. I mean, I
But
don't know.
and he also didn't. He didn't issue any
right.
contempt order, so he didn't
Right.
cover his ass.
Right,
If he had
but
done that, maybe.
Even if he had, there are procedures that have to be followed before you can put anyone in jail on contempt. There are procedures.
Right.
I'm actually working with another father out of Taney County, and he's complaining about corruption. Guess who his judge is?
Oh no, not Amy.
Oh, it is.
Oh my! Does he know about this?
Not yet, but he will.
Oh, well, you bring him the truth, Kenneth, because this is something.
It is, the question for immunity purposes is less about whether he exercised an authority lawfully given and more about whether what he did is something judges do.
Well, how frequently in Missouri or any other state that you're familiar with do judges take people to holding cells?
Children. I just wait. Really,
I wish I
seriously.
could see the judge's face.
What? I know, me too. What kind of argument is it to say, well, this is really not about whether he had the authority to do it, but about do judges do it is really the argument.
So I'm going to give you another one, Megan. It's out of West Virginia. Her name is Louise Goldston, and she left her bench. These are all the same things in the
I know
arguments
this
that they're
one.
doing.
I know
Yeah,
this
so
one.
she left her bench. She left her bench. She went to the father's house because the mom had requested some pictures, and I guess he didn't turn them over in time. She left her bench, took everybody in the courtroom to father's house. The dad is on the front lawn telling her, like, you don't have a warrant. You can't come in my house. This is against the law. She went in and started removing pictures off this dude's wall under the threat of arrest. And so now they're in appeals court because she's claiming judicial immunity.
Oh, that's insane.
Oh, and it's on film. It's on
She should
film.
be removed from the bench.
Oh, but she
It
won't
gets
be.
better. Hold on. It gets better. She is removed from the bench. She stepped down January 31st. They put in articles of impeachment to remove her one way or another with the West Virginia legislator. But
Absolutely.
there are now 2 more judges that work in the same district as her that they were caught lying on the record. So now they're looking at 5 counts of judicial misconduct for trying to cover up for Judge Goldston in West Virginia, who was doing inappropriate judicial actions. And so that's what I hear off of this video.
I'll tell you something else. That judge who did that in West Virginia, she should be civilly liable for damages personally for outrageously violating that man's right, Fourth Amendment right.
Here's what's even worse, though. After he filed the lawsuit, there was like 12 more families that came forward and were like, yo, this stuff happens all the time because she did it to us too.
That's insane. She should have to pay massive money
Court
damages.
field trip. What? A court field trip?
Yes.
Also, Ashley Casey on Locals, thanks for the tip, said the judge was way out of bounds. I agree with you, Ashley.
Out of bounds? I mean, this is so far beyond way out of bounds that it's hard to even comprehend.
But amazing. How many appeals, though, has the Virginia judge gone through now?
So she's all the way to the appellate court, like whatever district they're in. I know it's not 8 like we are, but they've already exhausted all of their state appeals, and the state said no.
Did she get free representation from her state's AG, or does she have a private lawyer?
I bet she has
So
the AG.
I'm trying to recall, but I think she's got her own private lawyer. So like the Missouri thing is way out of bounds because taxpayers are required to pay for all of this bull crap for these judges that are violating people's rights. But I think she had to pay for her, don't quote me, but I'm pretty sure she had to pay for her own attorney.
That would be
Well,
nice.
I hope so. That would be some small amount of justice.
All right, this gets even funnier, you guys.
Well, in this case, so this relates to the seizure issue. The question for immunity purposes, Judge Smith, isn't really an empirical question in the sense that, so looking at Stump v. Sparkman, that was a petition for sterilization. And I think the dissent there argued this has never been done before. What the Supreme Court said is, even if a petition is passed on only once, that doesn't vitiate immunity. What matters is whether it's a function normally performed by a judge. And judges do normally engage in what may be termed a seizure under the Fourth Amendment.
Judges do normally engage in kidnapping, so it's fine. So it's fine. So I mean, it doesn't really matter whether they have the authority. They regularly do it, and so precedent. That's my argument. This is literally this guy's argument. I want you to understand.
I still can't get over this Stump v. Sparkman idea that the Supreme Court said, if that guy is correct, that this is something judges do. That
This is something judges do.
Judges routinely order that young women be sterilized against their will.
Now,
What?
let me just say, judges will protect their own, and they do not want to eliminate the power that they have to control the people in their courts. And even the Supreme Court members will absolutely rule with their brethren in the black robes every time, which is why the Supreme Court should not be the ultimate decider on what happens to judges, because they are judges. It should actually go to Congress. Congress should decide what happens at the
articles
end.
of impeachment can be filed against
But
federal
they never
judges.
do it. They
Well,
don't
they should.
do
Well, if there were a federal judge who did something like this, they should.
This judge could have been impeached by the Missouri legislation. They didn't do it. Legislators, they didn't do it. They have no, and they know they can do it. We told them they could do it. Rosa, how many times have you told them that they can file articles of impeachment against these people?
Well, the issue is so they're arguing that under Stump v. Sparkman that judges do whatever they want, and so therefore we should leave it. And then the Missouri legislator, which I do have quite a few friends and contacts there, their argument is, well, damn, we've never done anything like this, so we don't know how to do it. Well, I'm telling you how to do it.
Don't they have lawyers? Now would be the time for them to go dig up the laws and figure it out.
Oh yeah, they have lawyers, and guess who those lawyers are beholden to? The
bar.
judges that they are arguing in front of. Do you think any of
you know what
those
they need to
lawyers
do?
want to go up against the judges?
Those Missouri legislators need to hire outside counsel from outside
Outside
of
the
the
state.
state of Missouri.
Dang,
The Missouri bar, Stephanie, has more power in the state of Missouri than the governor of Missouri. So when they pick judges, the bar gets to put forward their nominations or who's beholden to them. And the governor of Missouri has one less vote than the bar does. So there's a 7 vote. The bar gets 4 votes. The governor of Missouri gets 3.
Yep.
The bar has more power than the governor of the state of Missouri.
Written into their constitution, Stephanie.
Wow.
They wrote it into the Missouri Constitution that the bar gets to pick judges. The Missouri bar. It's sick. Sick.
Well,
you don't come up against the bar very often.
What does the law in Missouri say about who can start the process to impeach a judge for outrageously bad behavior?
The House of Representatives.
The House.
And is that held? Who runs it? What party runs that?
The Republicans. They're so useless in Missouri. Let me tell you something. I'm sorry. I know, Rosa, you have a lot of friends there. You don't have to agree with me, but they're so damn useless. They're so spineless. It's sickening. That
So would
Luke
it be
Meyer,
safe to say that they don't have a millstone conference in Missouri?
they do
like
not
the
have a
Oklahoma?
millstone. Nope, they don't have a millstone conference like Oklahoma does. And in fact, Tony Luchtenmeyer, who is the head of the Judiciary Committee, refused to meet with me or the parents the victims that I brought to the Capitol to talk to him. And he is the head of the Judiciary Committee, or he was at the time. And we sat in his office. How long did we sit in his office, Rosa? How long were we there?
He still is the head of the Judiciary Committee, but he's on the Senate side. So the House of Representatives is the one that has to start the proceedings. And it's like chickens with their head cut off. You've got 9 million different issues they want to get to, and pulling a bench off or a judge off their bench isn't one of them.
Mm-mm. No, they want something that gets them headlines and television reports, and that's just not going to do it. And if anything,
They don't think that getting a judge off the bench who hauled 2 little children off to lockup will not get them headlines.
Thing is that it'll also get them on the blacklist of the judiciary, and that's a real big fight that nobody seems to want to take on. Sky is a neighborhood says totally irrelevant to the topic, but Kenneth has a lovely smile. It's true. And Ashley says that Kenneth looks like Barnes. Rosa looks like Robert Barnes. He does look a little bit like Barnes. That's true.
So guys, doesn't the Missouri legislature hold the purse strings, and don't they fund the judiciary?
Yep.
So why is the legislature afraid of the judiciary?
Because the bar has more power than them, and the bar has more money. So they ran an ad to give the governor back more votes in 2012. The bar spent almost like $5 million on commercials to shut that campaign down, to give the governor back more power than the bar. And they've never brought up anything to regulate or bring the bar back under control since, because they got a lot of power and influence. But and Missouri is even more messed up, because we vote in most of our judges, and you can go to the voters and have them removed. There are 6 counties in Missouri, the 6 largest counties, that they are appointed by the governor, and that's the process that the bar gives them. And so it's even harder to get them removed than you were to recall a judge.
So in those 6 counties, can someone mount a campaign and run against one of those sitting judges?
I do believe so, but like I said, getting one removed would be almost next to impossible, because the legislator is busy.
Yeah, and also the bar backs the ones they want, so they have all the money. So good luck launching a campaign. All right, we got to get to this.
By a show of authority.
They do it, but not this way. I think this judge had a little bit of black robe disease and thought his power was maybe a little bit more than it actually was. And usually when you do something like this in state court, I used to be a state court judge, you actually go through some procedures. You don't walk into a conference room, you don't throw 2 kids into jail, make them take off all their shoes, put them in a holding pen, and then when they come out, tell them they're going to go to foster care if they don't listen.
Wait.
Two answers.
That's the judge. That's one of the judges.
That was one of the judges?
I think so. Who else is talking?
That's one of the appellate judges.
That's one of the appellate judges. That's why I told you this is so much fun. They're going to hand this guy his hat.
To that, Judge Strauss, the first is judicial. The context is, this is where the context matters. So the court was over, the father was out of the courthouse that day. He had already gone and the complaint says he couldn't get back in. So they're there in the courthouse with the mother and they're not complying with the custody arrangement that Judge Eighmy had pointed out. That Judge Eighmy had approved that day, that everyone was agreed was their welfare. So I think the analogy here, if we want to draw like a process analogy, it's almost like a motion for reconsideration. The children approached Judge Eighmy and said, we don't like this custody agreement. They knew he was a judge. We don't like this custody agreement and we don't want to go home with our mother today. And so Judge Eighmy was presented with a situation where the children were not complying with an order that was entered for their welfare. And
it's not a motion for reconsideration. I mean, there was no hearing. It was the non-parties that were objecting to this. I mean, it doesn't look anything like a motion for reconsideration. I mean, that would be a judicial function. And there are, as Judge Strauss indicated, procedures that go with that. And an order would issue. Right? An order would issue.
It's a bad sign when the judge is hearing your argument say, it doesn't look anything like that, like what you just said.
Well, plus procedurally, that just doesn't work, because if the kids had supposedly filed some motion for reconsideration, due process would require that the judge give everybody involved an opportunity to respond. You don't just make a motion and then the judge says, oh, okay, yeah, or no, I don't like it. No, that's not how this works. We have due process rights here.
Yeah, exactly.
Following that motion for reconsideration, and then it would be enforced presumably by an executive official, police officer, deputy, something along those lines.
And the point for judicial immunity in this case is that procedural problems, grave procedural errors don't vitiate an act's judicial nature. That's City of Haytuck.
Analogizing this to a motion for reconsideration to suggest that it was a judicial sort of function, because on its surface, it just doesn't look.
Well, the children approached Judge Eighmy as a judge. They knew he approved the custody agreement. They knew he could release them. The authority, and this is the authority he used to seize them, to quote unquote seize them, was his judicial authority. Mr. Rockett agrees to that in his brief. So they approach him as a judge. They ask him essentially, they debate about the validity of an order. They don't want to comply with it. And when they continue to refuse to comply with it, Judge Eighmy walks them down to the detention center and orders uniformed officers to take them into custody. That's very similar actually to Newman v. Indiana. The judge there, that was a seizure. They sued for temporary deprivation of liberty. The Seventh Circuit noted that, and it was a midnight hearing in the judge's chambers. And the judge, after the hearing passed, said, I'm not going to grant your motion, your extra hearing, and you need to stay in my chambers until the sheriffs are done picking up the child at your house.
Now, my understanding, though, and correct me if I'm wrong, is the judge walked out from chambers. He didn't have his robe on. And you're saying that the children actually approached him. I thought he approached the ensuing discussion that was happening in the courthouse lobby. Am I wrong about that?
I think that is correct, but the engagement with the children and the reason they followed him was because he was a judge. And so the authority...
No, he just lied. He said that the children approached the judge. And that's a lie. It's a damn lie. It's not at all true. Hey, is my child in here? Go and tell the other one that she needs to go to bed. Thank God. Okay, because I just realized she's not sleeping.
I'm sleeping in your room tonight.
Okay. Why, are you going to bed now? Yeah. All right. Sounds good.
He exerts, even under Mr. Rockett's reading of this case, is his judicial authority. And when they don't comply with an order entered in for their welfare and tell him multiple times that they are not, the detention itself is functionally akin to a contempt hearing, the individuals refusing to comply with the court order or otherwise thwarting judicial process. Or it's related, you brought up foster care, Judge Strauss, it's related to the authority of the Missouri Circuit judges to take children into custody when it would be in their welfare.
You know, I'm thinking that actually this doesn't fall under any government authority at all, which is an executive officer has to, an executive official, a police officer has to have at least probable cause or reasonable suspicion to stop and seize someone. He clearly didn't have arguable probable cause or arguable reasonable suspicion. So he wasn't using executive authority, and judicial authority ordinarily happens in a courtroom with, as Judge Kobus says, with some sort of process. So it doesn't appear that he's actually exercising judicial authority. And I don't think there's any legislative authority going on. So it seems to me like there was just no authority for what Judge Eighmy did.
Well, we point out in Missouri law that he is allowed sua sponte to do contempt. He is allowed to order ex parte. This gets to the Forrester v. White, I think, at the end of the day, the informal and ex parte nature of a decision of a court decision doesn't render it without immunity. Courts routinely issue ex parte orders. Mr. Rockett cites Lopez v. Vandevader out of the Seventh Circuit. The court there noted a plethora of orders that are issued by judges, not within the courthouse, not in the context of formal procedures. There could be ex parte motions, emergency motions judges have to rule on at their house.
There are orders issued.
Well, there was a custody agreement on the record that everyone agreed was in the best.
As far as for the detention of the children, there was no formal order.
No.
Well, he ordered the uniform officers to take him into jail.
But there was no order.
Record.
He directed them to take certain their shoes off and the bracelet off. Is that correct? I mean,
Well, yes, he escorted them, but then I would go to.
ordered them. They were in custody. Don't you agree?
They were in the same way the plaintiffs were in custody in Newman. The judge used his.
My God, if I were these judges on this panel, I would be like, bailiff, take him into custody right now. Take the judge into custody right now and put him in the detainment center down and take his shoes and socks right now. I've heard enough.
Wait, and do a strip search.
And strip search him with a cavity search, sir. And then, and you know what, Judge Eighmy? If you think that's a problem because you didn't get your due process, I guess I'll see you in court for the next 5 years. But that's what we're gonna do. We're gonna take him in custody right now. Let's go. That's me on the bench, by the way. If I ever get appointed as a judge, that's what I will do.
So much.
Well, that's what
Judicial authority to deprive them of their liberty. It's kind of the Fourth Amendment test. The point is the seizure, I think, analysis here, Mr. Rockett is trying to transform what's a functional analysis into a categorical analysis.
Counsel,
All Fourth Amendment.
You're into your rebuttal time. I don't know if you want to address the second issue or.
I'll address it real quickly, Judge Smith, and I think this one is actually very simple. Judge Eighmy has subject matter jurisdiction. Under Missouri law, subject matter jurisdiction is a matter of constitutional law. Child custody disputes are civil matters within the subject matter jurisdiction of those courts, within the circuit courts of Missouri. Furthermore, he has subject matter jurisdiction, and under Supreme Court precedent, under this court's precedent, that's sufficient. Furthermore, the order he issued was to bring the children into his court for a proceeding before him. So this is really on all fours with Morales v. Waco. This was an order issued in aid of his jurisdiction in the case before him. And in that case, it is clearly order issued with necessary jurisdiction that is without the clear absence.
One last question. My understanding is the Missouri Supreme Court mandamused most of what Judge Eighmy did. Was it only the second order, the first order, or both orders?
Only the second order, Judge Strauss, and only because of the recusal issue. If you read the order issue of the exhibit to the complaint, it wasn't for any jurisdictional. It wasn't because he lacked subject matter jurisdiction. It was because of the recusal issue. Okay, I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Talley.
That was his argument.
Mr. Eastwood.
All right, wait. Before let's just go around the table.
Okay.
How do you think? So we'll start with you, Stephanie Kimbrell, Esquire. How do you think the Attorney General's office did on their arguments in front of the 8th Circuit Appeals Court?
I'm giving him a D-.
A D-. D-.
Very generous.
That is very.
I'm giving him a D-, and the reason he didn't get an F+ is because he at least maintained an attitude of confidence, which sometimes can get you a little bit of the way towards, if you have a little, mojo going on, you can sometimes snow some people with that confidence, but the substance of his argument gets an F-. But overall, I'm giving him, what did I say? D-? I said D-.
All right.
Overall,
Rosa,
I'm giving him a D- because of the confidence.
All right. What's your how do you grade this Attorney General's lawyer?
I'm going to have to go against our colleague Stephanie and go ahead and give him the F. Just because he was hopped up on Red Bull that morning doesn't mean his argument was lucrative or in any substance to the matter. This judge was on a power trip. He exercised whatever he wanted to do, like leaving your bench and holding field day trips in somebody's front yard. And kids went to jail for it, unfortunately. And so, yeah, now the Attorney General's trying to keep it to where these people keep their immunity, but that didn't even come about until the 1960s, and then in the 70s it was done with the Stump v. Sparkman case, and so it needs to go.
All right, I'm going to ask a poll on YouTube. AG's argument gets, let's see, a D plus. I'll just say a D, an F, directly to jail.
Well, you didn't give us that option. That's unfair.
Let's see. I'm asking you, what do you think, community? Why is this not letting me push enter? No, I don't want to add that. I just want to get rid of it. Oh, there we go. All right, community, what do you think? I'm going to say directly to jail. Do not pass go. Do not collect $200. I want to see that lawyer locked up with Judge Eimy, barefooted and strip searched with a anal cavity search and the whole thing. That's what I want for both of them at this point. And I don't think that anything that comes after that is going to, well, that's what they deserve. They did it to children, for God's sake. All right, here comes Mr. Rockett's attorney. And this is going to get fun.
Please tell me he's way better than the other guys.
It's pretty good.
Oh, he's noisy too, getting ready at the podium.
Just a lot of paper shuffling. He's getting his mojo.
Chief Judge Smith, may it please the court, Hugh Eastwood for Bart Rockett as next friend of his minor children. The complaint here plausibly alleges 2 incidents in which judicial immunity does not apply. This court should affirm the district court. The facts here are admittedly egregious, extreme, and very unusual, as they are in most of the judicial immunity precedents, which are thankfully rare. Before I turn to my argument, I want to respond to a couple of things that occurred during my friend Mr. Talon's colloquy with you, Judge Strauss. The pleading alleges that the judge approached the kids, not vice versa, and this was after any hearing or proceeding was completed. In other words, the children were not having a visit to the judge with an expectation that the judge was going to be performing some sort of judicial hearing or function. Second, there was no foster care petition or hearing before the court. That makes this very distinguishable from those other line of cases. Even in Stump, there was a petition for sterilization, after all, before the court. And finally, on the Newman v. Indiana case that we had some discussion of with you, Judge Kobus, there, of course, it was adults who were who were parties to the court's orders, who were asked to stay in the courtroom while the deputies went out to seize the children, presumably because of sort of some concern.
Okay.
Just want to say that was a really good job distinguishing the cases that the other guy brought up.
Right. So he's saying that there were orders in those cases. In this case, there were no orders. There was not a foster care placement, so he can't be threatening foster care. There's no order for that. He can't be threatening anything, jail, because there's no contempt order, right? The other cases,
Right.
as egregious as they are, there
At
were
least there were
actual
underlying
judicial orders.
Yeah.
Right. And that's what gives them
Yes.
the excuse anyway to
Yes.
protect one another. So how lucky is Bart, by the way, and those children, that this judge wasn't smart enough to cover his ass by writing a contempt order?
Well, plus it appears he didn't even do this in the courtroom on the record. Did he?
Oh.
It was in the hallway where it started, right? And then he
Yes.
marched their poor little butts down to lockup.
I know, and I know what you're thinking. You're thinking, oh, for fuck's sake. And if you want to go over to the merch store, we have lots of new merch for you. Oh, for fuck's sake is my favorite. There's mugs, there's cups, there's all kinds of things. The merch store link is in the description, and it supports this show. So if you enjoy fantasizing about putting judges in jail and giving them cavity searches, you need to support this show, because you're not going to hear that anywhere else. So that's what we do here. But in order to support the show, you got to go to the merch store. You got to buy yourself something nice. There's all kinds of stuff in there. Go check it out. All right. Where are we at?
Sorry, just push play.
All right.
about interference by adult parties to the case. Let me turn to the first incident. Seizing a person is an executive function. It is normally performed by law enforcement officers, jailers, or in the case of children, doctors in Missouri. It is not a judicial function. And the fact that the judge said he was going to teach them a lesson or threatened to put them into foster care did not make it any more judicial function. Therefore, Judge Eimy's acts in the first incident here fall into—
Wait, I have to read this comment. Sky is a neighborhood says, just casual guerrilla judging in the hall. No courtroom or record needed, my man. You know, like, just a little guerrilla judging.
Okay, Sky is a neighborhood. That's funny. Really funny.
That's a new term we need to bring it. I'm going to call it guerrilla judging.
Casual guerrilla judging. I'm going to figure out a way to work that into a motion I'm writing.
That is so good.
It'll be in some type of a story tomorrow on the Father's Rights Movement.
You casual guerrilla judging. That's the way I'm going to describe what he did from now on to the end of eternity. When Judge Amy's name is printed, when I print it, I'm going to say the casual guerrilla judge from Missouri who judges in the hallway without any authority.
To those line of cases where judges were denied immunities for stops, for seizures, for prosecution. It's similar to Molina. This is where the judge stopped the motorist on his commute home. To Gregory, where a judge assaulted a litigant in his courtroom. To Lopez, the judge was denied immunity for holding a man at gunpoint, arresting him, and prosecuting him. But he did have immunity for issuing orders and sentences in his courtroom.
You know, one thing that I'm a little concerned about is state court dockets are they're immense. And if you've ever sat through one where there's 30 or 40 things going on in the morning, sometimes you see a little bit of street justice where the judge does some stuff that may come close to the line or maybe even sometimes even cross it in their judicial function. And I'm a little concerned that this is a strange case, but that that we're not venturing into some of those street justice areas. We should steer clear of them, particularly since you'd like for judges to have immunity when they're doing their very best to mete out justice and to deal with very difficult situations.
Judge Strauss, if you're getting to the second incident where we're
Mostly the first.
Okay,
yeah.
We'll stick with the first. Fair enough. Stump speaks not just to, of course, the function or act the judge engaged in, and it is a functional analysis. Judges do not normally seize children and throw them in jail cells after completing a hearing over their parents' custody dispute. But Stump also talks about the expectation of the parties, and that is important here. First of all, the expectation of the parties would be the parents' expectation. And there's no allegation that either mom or dad here expected the judge to throw the kids into jail. The kids at the time here were 12 and 14 years old. Their youth, their vulnerability meant that they were not even inside the courtroom.
Had it been suggested to the judge to leave the courtroom and visit with the children or talk to them? How did the conversation with the children arise after the completion of the...
How did the judge get the children alone in a room together? Let's venture down this road. How did this happen exactly? This is a great question from the judge.
In courtroom proceeding.
The complaint alleges, plausibly, that the judge, after court was done for the day, when he was no longer acting in any sort of judicial function or capacity, took it upon himself to approach the kids in the courtroom lobby. And we know that under the precedents that location is certainly not a dispositive factor. Judges can functionally commit acts of judging from their house in the middle of the night in their pajamas, signing a warrant, for example. But here the judge, to your point, Chief Judge Smith, the judge approached the children and sua sponte decided to get into a discussion with them about the custody order. This was not done inside his courtroom during any sort of proceeding, and it was also not done with the children's representative.
You know what else is really wrong with that? That's an ex parte communication outside the presence of the parties or their lawyers.
That's right.
That's totally inappropriate.
Their father was not there. Their father was asked to wait outside.
Or his lawyer. right?
Yep.
I mean,
His
that's
lawyer, I don't
totally-
think his lawyer was there. No.
That's totally inappropriate, most likely a violation of Missouri's judicial professional responsibility.
Oh,
rules
but
for
they don't have any
judges.
professional responsibility.
No,
Do
that's
they,
totally,
Kenneth?
it's
They
totally
have
inappropriate.
rules. But like I showed you my notebook full of the professional responsibility complaints, they just go like this. They go, oh, we'll throw that in the
Now,
garbage.
I will tell you that where was the mother? Was the mother there when all this
Yes,
was going on?
she was in the hallway arguing with the children. They were
Okay.
refusing. So she had Bart decided he would go out. He knew she had to break the news to the children.
Mhm.
I think he might have broken it to them with her, and then he said he was going to go wait in the car while they
Mhm.
had a conversation, a private
her.
conversation with her, because he didn't, he was trying to give her some
So
space.
the judge had this conversation with them in front of their mother, one of the parties, but not in front of
But
the
not
other
the other.
party.
Yeah. Oh, the
Totally,
mother wanted this to happen, Ashley.
totally inappropriate.
The mother wanted this to happen. There's some question. There's a possible. I don't know if I should say it or not.
Was the
it's
mother's
gonna-
lawyer?
There's more coming out on this.
Was
at
the
some point.
mother's lawyer present when this was going on?
I don't know. Probably. But there is some question as to what the mother's relationship was with the judge.
My phone's about to die, just FYI.
Why don't you plug it in?
Because my headphones are plugged in.
Well, you can unplug the headphones to plug the phone in so it doesn't die.
All right, I'll
GAL
go get my plug.
or with some sort of process of a hearing before the court with the parents and their counsel present. What I hear underlying your question, perhaps, Chief Judge Smith, is this question of alternatives. That's a really important point. The judge could have done all sorts of judgy things here.
Was the guardian ad litem still present?
No. The guardian ad litem was present during the courtroom proceeding that day when the parents entered into this sort of consent order, but no.
I just wonder whether, and this gets back to my question, whether the judge was doing judgy things when the judge came out, pulled the kids into the conference room. So far, so good. I've seen judges do things like that, and that seems judicial. I just got to be clear from you.
I know that judgy things was hilarious. Is this a judge doing judgy things? I mean, is this a legal term? Judge doing judgy things. Stephanie, did you hear that?
Yes, hilarious.
Do you guys use that term, judgy things?
No.
What you up to today, Your Honor? Judgy things?
Where he crossed the line. Did he cross the line later when he put him in jail? Where was the line crossed in your view?
The line was crossed when he took them into the conference room without the GAL and without the parents, I believe. But certainly the gravamen of our allegation is that is the seizure itself, and I don't think the seizure.
Hey, Steph, I think you're going to have to back out and come back in through the link because your volume is cracking like crazy. I think it's from unplugging the headphones. So back out and then just come back in through the link. All right, here we go.
Seizure started until he sort of dragooned, to use the word from Zarcone, the coffee case, dragooned the kids down to the jail cell, had them take off their shoes, had the boy take off his religious bracelet, which he had made a promise not to give up, and put them in these adult cells where they were sort of terrified because, of course, there was no boundaries to what would normally be considered an order. So I hold you in contempt, I'm incarcerating you for an hour, something of that nature. And there was no criminal contempt because there was no disruption of any judicial proceeding. That might be a different case for a different day, but here court was ordered over for the day.
Well, and you see what I'm saying? Family law is just a different thing. I mean, for those who have never done family law, there's so much informality, so much, many parties get together, they try to figure it out. And so it runs a little different.
It's too bad that he didn't say family court is completely unconstitutional, because that's the real thing. Here he is saying, well, family court is a totally different thing. Why should it be such a totally different thing where everything is willy-nilly and up in the air? Problem.
The
Stephanie?
Constitution is not suspended in family court.
Well,
Thank you.
It is, though. That's the way they treat it. And it's interesting to hear this appellate court judge say, family court is a different thing. That bothers me. It's like, no, it's really not. You're still supposed to have all your rights afforded to you in the family court. But they know it's different. They know that it's these things happen in family court. Lots of people get together to make decisions, and but that's not how it's supposed to be.
You know how
you know how Justice Gorsuch recently in one of those COVID cases wrote that there's no caveat to the Bill of Rights, there's no exception for a pandemic to the Bill of Rights? Well, I would say the same thing applies, obviously, in family court when people are potentially losing something far more important than property, something far more
The
important
Supreme
than
Court called it akin to the death penalty to lose your children.
it's
It is akin
horrendous.
to the death penalty. It is a
So,
death. It is a
so,
severing of a relationship between family.
so to pretend like the Bill of Rights somehow doesn't apply in those situations is just absurd. Of course it does.
So an actual ruling to come down, and I want to say it was either the 7th or 8th Circuit within the last 15, 20 days is that the family courts using restraining orders to circumvent the Second Amendment, because they always put the no firearm clause on there, is actually against due process and therefore cannot be done.
Wow. Which circuit was this?
I want to say it was 7th or 8th. I'll send Megan the link after the show, but that just came down. That was all over the place about 2 weeks ago, that the family court's usage of the restraining orders to prevent people from owning or participating in the Second Amendment is totally a due process violation and can no longer be done.
Wow.
Good. You know, frankly, they shouldn't hand those things out like candy anyway, which is what they do. And yet women who need them don't get them. It's bizarre. So if you're a woman who's using a restraining order as a silver bullet just to get a one-up in your divorce, you get it. But if you're a woman whose husband is an actual murderer and is actually going to kill you, you don't get it. It's incredible how dumb they are at handing out these restraining orders. I don't know why they continue to do it. It's like they're just trying to create more chaos. And maybe that's the point. I don't know.
Differently than other types of judicial proceedings.
Well, that brings me to the second incident in my remaining time before my friend Ms. Clark speaks for one of the amicus, which is that when he issued the pickup order, the judge had already made a determination that no party lived in Missouri, and he encouraged the mother to go to court in Utah. So this is a judge acknowledging with predicate factual findings that he lacked jurisdiction under the UCCJEA, and that statute is a jurisdictional statute. The whole point of it is to stop these sort of interstate squabbles over which court is properly.
Exactly.
That's a jurisdictional statute.
Missouri is in the minority of states that holds that the UCCJEA is not a subject matter jurisdictional statute, but that gets to the second point, which is judges' determination of subject matter jurisdiction is for actual cases and controversies before them. In Stump, there's a petition for sterilization before him. Here, there was no petition that would warrant a capias order, which is what this pickup order is. Those are normally issued in delinquency cases. There was no petition or motion for delinquency.
Wait, are you familiar with a capias order, Stephanie?
Habeas.
I thought he said capias, a habeas order. So a habeas order is a produce the body order, right?
Yeah, yeah.
So that's not really a warrant, is it?
Well, I think he's saying it's like if somebody, like I had a case where a judge held somebody wrongfully with a $30,000 body attachment. He issued a $30,000 body attachment and said, pick this guy up, bring him in front of me and me only, and he's not getting out unless he produces $30,000.
Whoa.
It was totally illegal. It was totally wrong. And the judge knew it was wrong. And when we filed a motion for him to reconsider what he did before our guy got picked up, but the warrant was out there. He could have been picked up at any moment. We filed an emergency motion in front of the judge to say, you need to reconsider this. Procedurally, this wasn't done properly. This doesn't comply with the contempt rules. This doesn't comply with the bail rules. This is all wrong, and you know it. Well, he knew it was wrong. He's actually a really good judge. He did it because he wanted to drag our guy in there to deal with the fact that he hadn't been paying his child support. And he figured that a $30,000 body attachment would get his attention and would get him to hire a lawyer. Well, that's exactly what happened. So he hired a lawyer. We filed emergency motion. We got in front of the judge. And in chambers, the judge told the other lawyer, who was real excited about the fact that the judge had issued this $30,000 body attachment, contempt is like prime reversal territory. And I think that I'm pretty sure if I don't reconsider what I did and I don't get rid of this body attachment, those two, meaning Ed and me, those two are going to be in court tomorrow with a habeas corpus petition for me to release him, and they're going to win. So he was kind of trying to get us all to the table to work it out,
Yeah.
which we did.
To make him
But-
pay the money that he owed.
Yes.
But still, it's basically a kidnapping with ransom.
Well, basically. But
I mean-
the point is, the habeas petition would have been filed, in our case, would have been filed in a higher court to say, release the body, produce
Release
the
him.
body
Produce
right
the
now,
body.
because you're holding him wrongfully.
Yeah. And so this judge used it to to get the kids back into his jurisdiction, which is bizarre because they were in another state.
But the habeas, so I think what the judge actually did was he issued like a warrant for their arrest, or a body attachment, a bench warrant to pick them
bench
up
warrant.
and bring the kids to him.
Yeah, but amazing that they stuck him in jail for 2 days first. I mean, like it's almost
Horrendous.
like he wanted them to suffer
It's
more. Like
disgusting
he
that they
wanted
did
them to remember that Judge Eimy said, "If you didn't do what I say, I'm going to put you back here." And
It's
then he
literally
did it.
despicable.
And then he did it.
So there was a
Horrible.
case out of Florida like 4 or 5 years ago. The woman's name was Jessie Weiner, and her husband was the one that was involved in the custody dispute case. They put a thing on there saying that she couldn't post about the case on social media. And then when she kept posting on it on her social media, which has absolutely been shown in court that you can't keep people from talking about these cases, even though if they do gag order you, they issued a contempt for her, and she spent, I want to say it was 60, 90, 120 days in jail before they could get a habeas corpus petition to get her out of jail for talking about a case that she wasn't even involved in.
That's crazy.
I like Ashley's question. Are socks really that dangerous that the kids couldn't have kept them on? Well, I guess if you have a very small neck, Ashley, you could strangle yourself with a sock if you could get it all the way around your neck and like twist it a bunch of times. Maybe.
How
Maybe.
gross they made those children go and lock up with bare feet.
It was just to make them uncomfortable. Linux Charm says, obviously, you could choke to death on socks. Yes, you would stuff the socks in your own mouth. It's just terrible. This.
In fact, the only thing before the court, which had already acknowledged it did not have jurisdiction, so the judge actually knew that he lacked jurisdiction, was a motion for contempt against the father. It does not follow from that a habeas order to pick up the children and take them into custody would issue. I mean, and this court's own precedents in Birch and Schottel analyzed the subject matter jurisdiction in terms of the matter before the court, the case or controversy, the petition before the court. In other words, subject matter jurisdiction is not sort of presupposed. It has to be conferred by the actual matter pending before the court, and that makes sense. There are precedents in the Missouri Supreme Court looking to a line of cases where courts of subject matter, even general jurisdiction, cannot sort of turn themselves into courts of inquiry and start adjudicating matters that are not actually before the court on proper petition or motion.
But sometimes courts get it wrong. I mean, I'm sure this court has been reversed by the Supreme Court because we've exceeded our jurisdiction in some case over the last 120 years, but that's still a judicial function that we've exercised.
Correct, but I think the distinction is errors or maybe even excessive jurisdiction versus clear absence. I'm going to go back to Bradley, Your Honor, Judge Strauss, which is this is more like the probate judge hearing the criminal case. The probate matter here was the custody dispute. Issuing habeas orders to seize children simply was not before him. And that's where that hypothetical is so important. Subject matter jurisdiction is analyzed within the context of the actual case or controversy pending before him. Finally, the judge does state this was a very unique situation. I have to differ. Custody disputes are routine throughout Missouri, the Eighth Circuit, the nation, and we do not see horrific fact patterns like here. Thank you.
Well, you do. They just don't get in front of the court,
Thank you,
actually.
Ms. Wood. Ms. Clark?
Now, this one bothers me.
I don't think I can stay for
May
Ms.
it
Clark
please-
and the
may it please
rebuttal.
Oh, you have to hear that.
My name is
It's
Victoria
it's
Clark,
only a
and I
couple more
represent
minutes.
Amicus.
Ms. Clark, would you bend that mic down just a little bit? We can hear
Certainly.
you a little better.
As I said, my name is Victoria Clark, and I represent Amicus, the Institute for Justice, arguing in support of Mr. Rockett. Your Honor, granting Judge Eimy judicial immunity here on this unique set of facts would be a historically anomalous outcome. In my brief time, I'd like to first address Your Honor's questions about the line between judicial acts and non-judicial acts, and specifically street justice, as Your Honor called it, because there is some daylight between the English common law doctrine and the modern American doctrine. But both doctrines are in agreement that on this unique set of facts here, Judge Eimy was not engaged in a judicial act, specifically when he jailed the children. I'd like to work backwards and start with Logie Sales versus New York. We don't cite this in our brief, but it's 442 U.S. 319. And there, the Supreme Court clearly held that a judge acting like a law enforcement officer is not behaving in a judicial capacity. In that case, the judge had signed warrants for a search of a business, but then the judge personally went and began to enforce those search warrants and then continued to search that business.
So this is
In that
something we just
context, the
do.
court said that the judge was not acting in a judicial capacity.
By the way, I have to stop here for a second because I have an objection. I object to the vocal fry in this woman's voice. She sounds like a very young woman. I just want to, again, encourage the young women out there to take the vocal fry out of your vocal tone. Just saying, it makes you sound less intelligent than you might be.
It's true.
I mean, do you hear this in court a lot, Steph? Are women talking like this to the judge?
Thankfully, I do not. And I'm in court all the time, and I don't hear a lot of that, even with young women lawyers.
Oh,
which is
good. I hope they're
great.
growing out of it. But this one really starts to get on my nerves after a while because her sentences start to trend down, and she starts to get in there. It drives me crazy. Stop it with the vocal
And
fry.
that is completely consistent with at least 400 years of English common law. In 1607, Floyd v. Barker, decided by Lord Coke, it's perhaps the most well-known judicial immunity decision in the history of common law. And again, it expressly limits immunity to judicial acts. Specifically, Floyd makes clear that subjecting individuals to out-of-court enforcement actions without any legal process is not a judicial act to which immunity attaches. Lord Coke wrote that a judge, quote, cannot be charged for conspiracy for that which he did openly in court as judge or justice of peace. But Lord Coke contrasted that with false and malicious prosecutions out of court which find someone guilty. And Lord Coke wrote that those could be amounting to an unlawful conspiracy. In short, even Lord Coke agreed that engaging in extrajudicial out-of-court enforcement actions was not protected by judicial.
The chat. Oh my God. I am like totally a lawyer.
I was actually going to say, she sounds like the barista at Starbucks or something.
That comment, that chat was very funny.
I can't even listen to what she's saying. She's saying it. It's so bad. I don't know who this poor girl is, but come on, train that voice. You don't need to do this at the end of every sentence.
No, but you know what else I can't stand? I can't stand when people argue by going like this. So then the next thing that I would like to tell the court is that, right? And I can't. I cannot.
It's very, see, this is why women have a hard time being taken seriously, ladies. You notice that we had nothing to say over with those men's arguments except whether they were good or bad. But now this woman has a great argument and I can't even hear it. I cannot hear it because she's talking like she's totally a lawyer. Like, hey, judgy, where you're doing the judgy things. And I just wanted to say, Your Honor,
No,
that
she's not doing upspeak. She's doing
a little
vocal
bit in the beginning, a little bit in her sentence, and then she goes way down here. And it's like, it's that one time at band camp. Yeah, it's not good. And this is woman stupidity. Like, I have been talking a lot about sexism and stuff, but this is one of the things, ladies, that make you look dumb. It just makes you look dumb. And this poor girl, she's not dumb. She probably went to many, many years more of school than I did. For sure she did. She's arguing in front of the appellate court. But goodness, anyway.
immunity.
Oh,
So
that was
while the
really
modern
big.
judicial immunity doctrine gets a lot of things wrong about the English common law, it is an agreement on this one, specifically Judge Amy's, acting like a law enforcement officer and deciding to personally jail the children after the custody agreement. That was
I was just going to ask, do you agree with where the line is, though? I mean, at least in terms of pulling him into the conference room, talking to them, trying to convince them that the order is in their best interest. Do you think that was a judicial function?
I don't.
Your Honor, we would defer to Mr. Rockett's counsel on that. However, what is really clear, the Supreme Court in Forrester has said that the line between judicial and non-judicial acts is fuzzy. So perhaps that's a fuzzy area. What's not fuzzy was the actions that came after it, where the judge personally sees the children, march them down to jail. And at that point, he was not behaving like a judge, he was behaving like a police officer, and so he's not entitled to any special protections for behaving as a judge. Additionally, I would like to talk very briefly about the jurisdictional piece of this argument. Again, I defer to Mr. Rockett's counsel on the specifics of the modern doctrine of jurisdiction here. But what I will say is that historically, English common law courts looked at both subject matter jurisdiction and personal jurisdiction in making the determination of whether immunity applies. And there's a case, Holden v. Smith. Again, we didn't, I believe, cite it in our brief, but it's 117 English Reports 323 in 1850. And there the court held in a case that it's very similar facts to here, that a judge didn't receive judicial immunity for exercising jurisdiction that the judge knew was outside of his personal jurisdiction. The judge in Holden had a case that was initially properly before him, but then he found out that one of the litigants in the case had moved into a different county, and the court attempted to enforce a contempt order out of the county, even though the judge knew for a fact he did not have personal jurisdiction to do so.
On the first issue, you indicated that English common law and American judicial immunity agreed. On the second issue, is there agreement or not
Yes.
related to personal jurisdiction?
Yes, Your Honor, there is, specifically related to personal jurisdiction. And so, again, the historical grounding of this argument, the Supreme Court has grounded judicial immunity in the English common law. And so, this court certainly could and should decide that personal jurisdiction as well as subject matter jurisdiction.
What's the difference, though, or what's the dividing line between making a mistake or making an error of jurisdiction and clearly exceeding your jurisdiction? Because I think that's the comparison or that you're trying to draw, and that seems to me to be even a fuzzier line than some of the other ones we've talked about.
Yes, Your Honor, I see I'm out of time. May I briefly
You can answer the question.
Thank you. Yes, Your Honor. So the line is fuzzy in some cases again, but here it's not. Judge Eimy knew that he did not have jurisdiction. He even at one point ordered the children's mother to consider refiling in another state because he understood that personal jurisdiction was fuzzy there. And then he continued to issue orders in the case, and even the pickup order for the children in a different state, knowing it is in a different state, and then ultimately causing a Louisiana court, to sign a warrant to seize the children. So Judge Eimy knew that he was acting outside of his jurisdiction and continued to act anyway, which is on all fours with Holden v. Smith. And for these reasons, we respectfully ask the court to affirm the judgment of the district court. Thank you.
Thank you, Ms. Clark.
Miss Clark.
So there's an ongoing case out of the state of Rhode Island where the judge did the exact same thing and had the Texas Division of Family Services go by and pick up a kid on a Delaware pickup order that they argued the jurisdiction and stuff on, and that hasn't went to any of the appellates or anything yet. But so I am actually seeing this more than just in this Rockett case.
Yeah, I mean, these judges are incredible. I want to see more of that. Rosa, when you have time, if you can send me a link to that case, I would like to read about it. Linux Charms sent $10. Thank you, Linux. Says, oh my God, here's your super chat. I put a new poll in the this is the first time I've done a live stream that's gone almost 2 hours with 0 super chats. I said, are we going to stay at 0? Because and the two questions were hell yes, we're broke, or no, here's a super chat. And Carl sent in $10. Megan, cook me some food now. Well, you need to join over at meganfox.locals.com. I'm cooking over there all the time, sir. or late, ma'am, Carrie, sorry, Blurple Dragon. I didn't mean to misgender you, Carrie. Like, oh my God, we need funds. Here you go, love. Not much, but I'm on a tight budget. Love you. Love you though, and want you on forever. Aw, you're sweet, Ellie. I appreciate you. Yes, like giver, you sure did. Elephant, thank you for your time. We appreciate you bringing us into the loop on these grotesque cases. Oh God, they really are. They're really terrible. And there's
They
only
really
a few.
are.
There's only a few minutes of this left, and so we should hear how it ends. More shuffling. Shuffle.
We're back to the AG.
I like how there's like this going on.
Thank you, Your Honors. 2 quick points on the pickup order and jurisdiction writ large, and then a couple quick points on the detention. There's one overarching point, though. Mr. Eastwood came up here and said there was no case or custody before Judge Eimy. There was no case before Judge Eimy. There was a case. There was a custody case before him. There's been a custody case before him this entire time, which leads into my second point relating to the pickup order and personal jurisdiction writ large. There's been Mr. Eastwood, Mr. Rockett has not refuted the point that Judge Eimy had UCCJEA jurisdiction. The 2009 custody arrangement was issued out of Taney County Circuit Court. So under Missouri law, Taney County Circuit Court had exclusive jurisdiction to modify that order. Secondly, even viewed under kind of an original custody order or custody proceeding, Judge Eimy had jurisdiction because the California court had declined jurisdiction in the 2013 modification case in a call with the judge.
How does that extend to the obtaining of a habeas pickup order for the children themselves?
Well, so firstly, that establishes jurisdiction over the custody dispute, which is what Mr. Rockett argues. And secondly, establishes that the pickup order was indeed an order issued in aid of the proceeding before him. That is a custody dispute that was correctly before Judge Eimy. More broadly, Mr. Rockett and the amicus is wrong that personal jurisdiction is necessary. Stump v. Sparkman and Bradley v. Fisher focused on subject matter jurisdiction. This court's precedents all focus on subject matter jurisdiction. Indeed, the case that Mr. Rockett cites, Duba v. McIntyre, when it discussed personal jurisdiction, did so in a litany of jurisdictional concerns, kind of in a vein of the jurisdiction is a word of many, too many meanings idea that we see a lot out of the Supreme Court, and ultimately held that for purposes of immunity, the question is whether defendant's action is authorized by any set of conditions or circumstances. That's on page 592 of that case. That leads, I think, also, that segues very nicely into the detention of the children. There was a question here. Mr. Eastwood was drawing lines between exact.
Very nicely into
that segues
minor
very
children in
nicely
jail.
into the detention of the children. That just see what I mean about this guy's confidence.
Yeah.
He's ridiculously confident. I mean, you have to be ridiculously confident to say something like that.
Well, he's come a long way from the beginning, because if you remember, he couldn't even say detention when he first started. He was like, when he took the children to the holding, the detention. Now he's full on. That segues very nicely into the detention of the children, as if that's acceptable in any way. Blurple Dragon, the YouTube memberships are still not set up. They told me I could have them. I set it up, and they have not approved it yet. And I keep sending emails to them asking, "Hey, what's going on with my memberships?" And I get no responses. You can't go. There's like 30 seconds left. There's 2 minutes. There's 2 minutes left. You have to hear. You have to hear the end. Now, just be quiet and sit there for 2 minutes.
Executive and judicial functions. Judge Strauss, I believe you mentioned that. Out of the 11th Circuit, the Harris case cited by this court favorably in Woodward v. Hulshoff, a judge there ordered a prosecutor to initiate charges. Initiating charges is prototypically or regularly considered to be an executive function, but the 11th Circuit held that the judge could do that under state authority. He could bind people over, and as a result, even though that was categorically maybe an executive function, it was also a judicial function in the context of that case. So kind of pairing that with the language from Duba about any set of conditions or circumstances, what we have here is a judge who is faced with children who do not want to comply with a custody agreement that was entered into for their welfare. He talks with them, they tell him they don't want to comply, and he eventually orders them detained both as a type of contempt proceeding or analogous to contempt and analogous to his authority to hold them in custody for their welfare. Last point on this record dispute, Mr. Rockett in his brief argues or cites to Joint Appendix page 18 for the proposition that Judge Eighmy approached the children. I just reviewed that. It's ambiguous as to who approached who. Maybe Judge Eighmy was walking out and saw what was going on in the courthouse lobby. But I will point out that that claim is not, in my reading of the record, supported by the record. And for those reasons, we would ask the court to reverse the district court. Thank you.
Thank you, Mr. Tallow. Court thanks all counsel for your participation in argument before the court this morning. We'll continue to study the briefing material.
All right, that's over. So nothing else happens. Thank you, Ashley in Locals, for the tip. Thank you very much. I appreciate that. Stephanie, any last thoughts before you go off and fall asleep immediately?
My brain is so fried. I can't. I've worked so hard on this case the last 2 days, and I have to go back tomorrow. Today was my day off. I was working. Tomorrow's my day off. I'll be working.
Oh, I'm sorry.
And
I'm sorry. I know work is
I'm
tough right
exhausted.
now. All right. Well, good night. Thank you for being here. I appreciate it. It was fun.
It was
I
fun.
haven't seen you on here in so long, and the chat hasn't been able to see you. So
I know it's been a long time. I'll come back again soon, hopefully.
yeah, we need to do it again. All right. Love you.
Bye. Love you.
Bye. All right. I got two more super chats. Ashley, thank you very much for the super sticker. And Sky is a neighborhood. You too. Like, girl, been too obsessed with the cause gorilla judging to super chat until now. Like, for real, babes. Like, for real. I got to tell you, Rosa, what are your thoughts on this whole thing? What do you think the chances are that they come back with a yeah, we're going to let him keep his immunity? We think that the district court erred. What do you think are the chances after hearing that?
I don't think so. I think this one's so egregious that these judges aren't going to get in trouble or pulled off of their benches by citing some type of clerical error. This Judge Eimy was definitely outside of his jurisdiction, as indicated. And I think the young lady for the amicus, she had, I think she's very well educated, and they've got an argument here. But the most egregious thing to me here is that the state attorney general is providing free lawyers for a judge that clearly erred on the wrong side of the law.
Mm-hmm. Yeah, that's a real problem. And that should be, I think that's what I'm going to write about. I'm going to write about the fact that the taxpayers have to pay for this. This is now the third appeal, I think, or no, second appeal, but third hearing on this. So there was the first motion to dismiss, which was not granted. Then there was the appeal that was also not granted. And now we're at the federal circuit court appeal. So this is the third time that they're trying to get out of this. And I just think it's really disgusting. Due process now. Enough of this. Speaking of due process, by the way, if you're a person who's interested in due process, you should pick up my book, Believe Evidence, The Death of Due Process, from Salome to #MeToo, because it's all about these issues and about why justice is important and why due process is important. It's on Amazon. You can go get that there. But Rosa, you've seen so much of these due process violations in Missouri. Do you think that this case, and I do think they're going to take his immunity away, do you think that this case will have any ramifications in the court system in Missouri?
I think this will force them to make some changes, but like I said, this case is so egregious. What we see is that if you're poor, you can't get justice. You can't go 3 steps into an appellate court. You can't go to the circuit level. You can't go to the appellate level. You damn sure can't make it to the federal appellate level because it costs tens, hundreds, $1.5 million to get to that level. And I think he's going to lose his immunity, and the Supreme Court's not going to hear this. But for the poor people, which mainly affects family courts, they can't get this type of justice.
No, and the Rockett family, even by their own admission, Bart was saying, he has people to thank, celebrity families who actually are funding this for him, who have, chipped in to fund this lawsuit. And yeah, normal people cannot afford this. I know even the Rockett family, I know that when I spoke to him months ago or years, I guess it's been over a year now when I did that first interview with him, he was strapped for cash then. So I don't know how he's gone this far. I mean, and you're right. Why should our justice system be a place where you can only access it to the truest extent of where you need to go, which is these appeals courts, right? Because if you're in a corrupt system, you're only there to get to the appeals court anyway. Why should that only be accessible to people who have money? That's wrong.
It's exactly the same thing we've seen out of the Clay case in Texas jurisdictions, where the mom was killed in a car wreck and dad was the only surviving parent. He went and picked his child up. Like 9 months or a year later, he gets served with a visitation order from the boyfriend saying that he knew the daughter for 5 or 6 months and therefore he should be entitled to some type of custody arrangement in courts with the father. And to you and I, that seems like it should have been shut down right there, right? No one has a right to your child just because they knew him for 5 months. Mom's deceased. You know what I mean? It cost them $1.5 million to take that all the way to the Texas Supreme Court. In order for the Texas Supreme Court, because they kept switching it, I think it was either the circuit level or the appellate level, they overruled the other court and then they overturned and redid. And then when it got to the Texas Supreme Court, the Texas Supreme Court said, no, dad's the only one that has rights to the child, but it still cost them $1.5 million to get to that level. So I feel sorry for the Rockett family that they're having to go through this and spend that type of money, even if people are donating. But most people just can't get this kind of justice.
No, it's true. They can't. They cannot. Mr. Hellspawn, thanks for the super chat, says, fine, guilt a poor disabled vet into gifting you cash. Fine, take my money with a smile. Well, I appreciate it. Thank you. Now I feel bad. Now I'm going to have to give it back. Oh, man, disabled vets. Well, thank you for your service, though, sir. I appreciate that.
Absolutely.
What is going on, Rosa, in Missouri right now? What are the cases that are you working on? Anything new that we need to know about that I don't know about yet?
Like I said, I'm involved with another father. I don't want him to be retributed against or penalized.
I understand.
So
that's why I don't take these cases, really. I was just telling somebody the other day, I got an email from somebody begging for help in one of these cases, and I wrote her back. I said, listen, one of the reasons I don't do these cases anymore is because maybe out of all the people I've tried to help, I helped one of them. One of them was actually helped by the media attention. The rest of them were retaliated against by judges and by the lawyers involved. And I can't be a part of that. I can't be a part of having children further harmed because of these people who get angry and they retaliate with this power. You saw that in this case, the judge used his power because he was angry to actually put children in jail. There is no low to which these people will not sink. So I understand why you don't want to name the case or talk about it, because if you do, they'll come after him to teach you a lesson, right?
Absolutely. They'll stick the IRS on you. After you and I did the national media coverage of my case, suddenly I got a 7-year IRS audit.
What?
Miraculously.
You didn't tell me this.
That alone, I've had to hire attorneys and they're auditing all of my stuff. That's probably that little call. Whoever made that call is probably going to cost me on the upside of $25,000, because if you speak out against this corruption, they will come after you.
Rosa, you didn't tell me that you got audited. You didn't tell me this. I didn't know this happened.
So I have I'm not throwing him any shout outs, but I have his name's Lance Drury, and he's been doing this for 30 years. He's like the largest IRS attorney for the people here in the St. Louis area. And he said he's never in his 30-year career seen someone get an entire 7-year audit like I have. What did I do to piss someone off? That was what he said to me.
So you're going to be under an audit for 7 whole years? You're going to
No,
have
they want all of my records.
They want to go back 7 years.
Yeah. So he's never seen a client get audited past 3 years and 30 years of practicing IRS audits. So I'm his first one.
When did that happen? When exactly did they do this to you?
About a month after coffin dying Judge Walsh's decision.
Oh my goodness. So you sued. Did you sue the judge in I know you sued Elaine Pudlowski.
I did not. I left the judge out of the lawsuit for the mere reason that I knew they were going to hide behind absolute judicial immunity. So I only sued the guardian ad litem and the therapist and the actors that were involved. And then they hid behind quasi-judicial immunity and said, and the best part was Judge Joe Walsh on that recording was saying that he understands crimes were committed against my children and I, but because they work for the state of Missouri, they can't be held liable.
That's the same argument that this stupid lawyer the AG's lawyer is making to the appellate court, saying, well, wait, he doesn't have the authority, but judges do it all the time. So, it's the same argument. It's unbelievable. This is so terrible. Okay, so what is the news, Rosa, about Michaela's Law? Is anybody interested? Now, for those of you who don't know, Michaela's Law is a law to remove immunity from the court actors like the guardians ad litem and the doctors, the psychiatrists that the court appoints who have been accused of massive fraud, by the way, against the litigants in court. Anybody going to pick that up? Anybody going to sponsor that bill?
No. What they have done, so there is a family attorney. Actually, I shouldn't say family attorney. I might misspeak on that. So there was a representative. Her name is Mary Elizabeth Coleman. She is now a Missouri state senator, and she just introduced a bill this Senate session and this is right after all of that negative publicity we brought the state of Missouri on guardian ad litems, but it is a reform bill for guardian ad litems. Like, you can't just go out there and bill the hell out of these parents and just say, oh, I did $25,000 worth of work, you owe me $25,000. Like, there are some things in there, guidelines that they have to start following. You can't just jump in 2 years into it and show up in court. You actually have to go meet the parents within 60 days and the children. And so they have introduced some things in her bill, and I'm thankful for that. It's not perfect, but it's a starting point. So I'll give her props on that to start putting guidelines in place for future transgressions not to happen.
Interesting. I had Evita Tolu on the program the other day. She talked about that in detail. We read parts of the bill. It's an okay bill, but there are things that need to be changed. And one of them is they need to put in the removal of the immunity in the bill. We spent some time contacting Coleman the other day, trying to tell her, you need to put Michaela's Law basically into this bill. You could do it with one sentence, that they will not get quasi-judicial immunity if they violate their professional conduct. And we can prove that they did violate their professional conduct all over the place. But the state of Missouri is like, well, they have quasi-judicial immunity, so it really doesn't matter because,
There's another representative, I can't remember her name, but it's House Bill 66, I believe. And basically, she's pushing for stiffer penalties to keep the parents from, I guess you would call it parental interference or kidnapping. So there's stiffer penalties in that. Her son, the woman went against the court order and took off with the kids to Texas, and they never got them brought back to Missouri. So in this case, the judge just goes to Louisiana and picks them up no matter what. And then it takes, this representative and her son almost a year to get the kids brought back to Missouri. But there are cases where it's necessary and warranted, right? But you have to keep in mind they are children. There's ways to handle things, and just snatching them out of a hallway and throwing them in holding cells and doing all that stuff to him, that's abusive. And he was outside of his power and authority in this Rockett case.
Yeah, it's a terrible abuse of authority. And that's a great way to actually, end this discussion. They're abusing their authority all over Missouri, and we need to start holding the Attorney General's office accountable to stop abusing the Rockett family, stop paying for the constant appeals for this judge, this out of control judge. Rosa, where can people find you? What do you want to show them? What you're working on next? Where do you want to send them where they can support your work?
Everybody can find me over at the Father's Rights Movement. It's on Facebook, TikTok, any social media platform, tfrm.org. I don't just help fathers, even though that's our name, Fathers' Rights Movement. Obviously, fathers get precedence, but if it's some type of court corruption, I'm usually behind it, trying to help out in some type of way. And I've been there through everything that everyone has faced, you know, including having to sue your court actors and all of the judicial abuses and things. So the stories really don't surprise me anymore. It's just like, how egregious can they get?
Yeah, one of our commenters on Rumble said the process is the punishment. That's true. That's very, very true when it comes to family courts. But Kenneth Rosa is a really good advocate. He's somebody who I've worked with him on many of these cases, and he really does care about everybody, not just fathers, but mothers too. And it's great when fathers and mothers can come together, both sides that are equally abused, and help one another. So thanks for hopping on tonight. I appreciate that.
Yeah, thanks for the last second invite. You know, and if you want to talk about anything else, just hit me up in the future, and make sure you get me a link on this or any articles you write on the Rockets, and we'll talk about this tomorrow on the Fathers' Rights Movement.
Yeah, absolutely. Will do. Talk to you later.
All right. See ya. Bye.
All right, guys. So here's the deal. What's going on with me for the rest of this week? Well, you can find me on Locals, meganfox.locals.com. That's where you'll find the rest of my live streaming for probably tomorrow. Here's something interesting. I'm filling in for Shannon Joy. She has a Rumble podcast that I will be filling in for her on Wham 1180 and on her Rumble podcast on Monday at 5 p.m. And I will drop the link. You guys, if you're not subscribed to Shannon Joy on Rumble, she just started a Rumble channel, and like, she's kicking my ass, which I kind of hate because she just got on Rumble. She's one of my good friends here. I shouldn't say I hate it. I'm just jealous. She's kicking ass on Rumble. And let me put the link in the Rumble chat for you guys, and I'll put it on YouTube too, and in Locals. You got to follow Shannon Joy. She's awesome. She is a local radio talk show host in the Rochester area, but she has just launched her Rumble channel, and she's doing so well. I'm going to be filling in for her on Monday, and so you can tune in to that channel on Monday at 5 p.m., and you'll hear me there. Now, as for next week and my streaming schedule, normally you guys know that I stream Monday through Wednesday from 11 a.m. to 2 p.m. Eastern Standard Time. Next week, the kids are on spring break, so I'm not going to be able to stream during the day because I'm going to be, hanging out with them and taking them to see their friends, etc., and going to movies and stuff. So I will be streaming at night. I have decided that I'm going to stream from 8 to probably 11. 8, 9, no, wait. Yeah, 8, 9, 10, yeah, probably 8 to 11. So all next week, there will be night streams from me. I will not be doing streams during the day. Mr. Fox is actually traveling, so me and the kids are going to be pretty busy, but I'm going to do night streams. Now, coming up next week, on Monday, I've got Rachel Bruno. She is going to be here. She is a victim of CPS corruption. She was one of Sean McMillan's clients. He won a couple $1 million for her when he took her abusers to court. And what they did to her family is horrible. And she wrote a book, and I want you to know about it, and I want you to hear her story. I covered her story years ago, and she told me way back then she was going to write a book, and she has, and it's out now, and we're going to talk about that. She'll be here Monday night. And then, get this. I told you guys that I am going to make an effort to get more women on this show, because I was complaining about women not being platformed in places, and so I am going to do that. So, Allison Morrow. Do you guys know Allison? Allison Morrow is, in fact, she just sent me a message. Hold on. She wants to know if kid interruptions are okay during this stream. They're fine. I'm a mom. I get it. Allison Morrow, who is a journalist, she is going to be with me, I think on Wednesday. She said she could come. Did I say Wednesday? Wednesday, we're going to do a little bit of an earlier stream for Allison because she's got her kids by herself. Also, she and I are both going to be home by ourselves with our kids. We're single parenting for a couple days, and she is going to be here at 6 o'clock. So we're going to do on Wednesday, it'll be a 6 p.m. stream, and she'll be here with us. So that'll be great. And on Wednesday, I'll be taking your calls. So it's going to be fun. And on True Crime Tuesday, Joe Raffa's going to be here again. Joe Raffa, retired sheriff's detective, deputy in homicide from LA County. We are going to be talking about Shabusiness. That's right. We're going to be talking about the Shabusiness case, and I have an announcement to make. If that trial is televised, I will stream it. Are you ready? Are you ready for Shabusiness? This trial, by the way, is the sickest thing ever. It's so bad, and I've got the documents. We're going to read over them on Tuesday, and for sure, bring your little piggy banks because they are going to demonetize me as soon as I start reading these documents. Oh, God, they're so bad. And Joe is already, oh, thanks, P. Beaver, for the Rumble rant, sent $5 and said, keep up the good work. I appreciate that. So, yeah. That's going to be fan-freaking-tastic. It's going to be so, so good. Billy wants to know, is this show ending soon? Yeah, I think it is ending soon. It's 11:30. It's a school night. I got to get up very early to get my kids on the bus and stuff. So let me check locals and make sure. Yeah, okay. We're all good in locals. Why are you talking about 8 a.m.? I said 8 p.m. 8 p.m. I said p.m., not 8 a.m. 8 a.m. Next week is night streams, you guys. So Monday, Tuesday is going to be 8 p.m. Wednesday, 6 p.m. because Allison Moreau is going to be with me and she needs it a little bit earlier. So we're going to be doing that at 6. Who else wants to know something? Anybody? Any more questions? You need to bring Vices along for this case. I think Vices is also streaming it on his channel, and that's okay. I'm going to stream it too. I don't really... although Vices invites me onto the court cases sometimes, but you know, the lawyers like to keep it with the lawyers on those streams, and so that's okay. I do my own thing. I do my journalism take on it, and we have our own style over here, and it's okay. I feel like it's only a 5-day trial, and I can certainly do it for 5 days. I can definitely do it for 5 days. And yeah, I think Vices is going to stream that trial as well. But there will be plenty for everybody to go around. It won't be any problem. No problem to have a couple of streams. And trial streams are good business. So if it's supposed to start in March, if it starts next week, I will be surprised. So it was scheduled to start on March 3rd. But if you know anything about Shabusiness, those of you who don't know who Taylor Shabusiness is, she's a psychotic woman. Well, actually, she's not psychotic. She's a psychopath who dismembered her boyfriend, cut his head off, stuck it in a bucket, along with other body parts and organs. And it gets so weird. It gets so weird. I can't even, we're not going to go into it now, but it's a horrifically brutal case, but it's only a 5. Yeah, it's supposed to start on the 3rd, but I don't think it's going to now because I don't know if you know this, but she attacked her attorney in court the other day. They had a status hearing or something. In fact, I'll show you that. Let me show you that clip because it's insane. Attacks attorney. Where is it? Yep, here it is. Okay, so Taylor Shabusiness attacked her attorney during the hearing, and her attorney immediately asked the judge to get him off the case. Shockingly enough, he doesn't want to be on this case, which no one can blame him, really. I mean, if you've got she's trying, though, to convince the judge that she's not fit to stand trial, that she's criminally insane. That's what she wants them to believe.
This woman charged with a gruesome murder attacks her attorney in court. Just some crazy moments. Here, get a closer look. Wow, Taylor Shabusiness had to be restrained during the court hearing. She attacked her own attorney just moments after the judge agreed to delay her trial. She faces several charges for homicide and manipulating a corpse and has pleaded not guilty.
Okay, so I got to tell you, this is not going to be a boring ass trial like the Murdoch trial. That's for darn sure. It's going to be a very exciting trial. We already got to see the bailiff tackle the defendant, which is something you don't get to see very often. So, wow. I mean, that's a lot of fun, isn't it? So, what else did she? Yeah. Oh, you guys, I can't even talk about. So I thought perhaps Shabusiness was an actual last name, but it turns out I found out that she had her name changed to be Shabusiness. That was something she made up. So yeah, that's a fake name. Yeah, you guys don't even want to know. Manipulating a corpse. Oh, it gets so bad. Look, guys, the world is ending. It's the end of the world as we know it. It's the end of the world as we know it. And I don't feel fine. I'm a little freaked out, to tell you the truth. Yeah. I personally think it's an act. I think that she's trying to get the judge to say that she's insane, but it's not going to work. She's had like 2 or 3 psychological evaluations, and they've all come back that she's competent, she's not insane, and she needs to stand trial. And let's see, what is the latest on when the trial is going to be? Because I think, let's see, business trial date, because it was the 3rd, but I think they've changed it. So they've pushed it back to May now. The trial was scheduled to start March 6th. Sorry, not the 3rd. It was scheduled to start on the 6th and last 5 days. But did it get moved? The court ruled Shabusiness competent to face trial back in May. Oh, so no, it wasn't moved to May. So it appears to be still scheduled for the 6th. So I don't know. Because I thought that she was asking for a delay in trial and that the judge granted it, but it's not saying in this article a different date than March 6th. So I'm just going to keep an eye on it. I'm going to keep an eye on it and see what happens. If it starts in March, and I can, and I'm here, I'm going to stream it. It'll be great fun. And I'm going to try and bring back the old crowd. I'm going to try and bring back Sean Kohlmeyer. I'm going to try and bring on Gadfly, get him back in here. And it's going to be a lot of fun. And Stephanie will drop in during lunchtime when she can. It's going to be great. It's going to be good fun. Yeah, she deserves an Oscar for her insane behavior if she's not actually insane. Well, there's a difference between insane and sociopathic, right? I mean, you can know what you did was wrong, which is all they need to put you on trial. And to be competent and not criminally insane. Criminally insane is a pretty high bar, I think. So it's going to be interesting. All right. So do you have the schedule down? Schedule is tomorrow, probably live streams on Locals, meganfox.locals.com. And if you are not a member of Locals, it's only $5 a month. And if you want to sign up for the whole year and you use promo code SQUATS, you get 2 months free on me. And we're doing cooking streams over there. We're doing freezer meals. We're doing cleaning streams. Today we did chicken repair. We did a chicken coop repair today. I found a big hole dug underneath the fence that I think the chickens actually did. Because if an animal had dug under there, they'd all be dead. So I think it was the chickens. So I got that squared away. I got 1 more egg today. That was good. And so tomorrow we're gonna do probably more local streams. And then Monday I'm filling in at 5:00 on Shannon Joy, on Rumble, and on Wham 1180. And Monday night at 8:00, this regular show will be happening on YouTube, Rumble, and Facebook. And Tuesday, same thing, True Crime Tuesday. And then Wednesday, 6 p.m. And that's when Allison Morrow hopefully will be with me. And we're going to have a good lineup for next week. So Monday, we're going to talk about some CPS stuff with Rachel Bruno. And I'm going to have other stuff there too. We're definitely going to have Ohio train updates on what's going on there. The chickens are trying to escape. I think the reason that they were digging there was because they like to dig for bugs. And I think they just got, they like to dig up the dirt too and get dirt baths. And so they make it all soft and then they get in and they squirm around. And I don't think they meant to dig a hole under their fence, but they did. So it was funny. So if you guys are not on Locals, let me show you, by the way. If you're not there, you need to go there. If you're on Rumble right now, you can hit that red button and you can join the Locals. It says join. It's the red button that says join. Here, I'll show you. meganfox.locals.com is where you need to go. And this is the kind of stuff I'm doing out there. I'm doing on Locals. It's hilarious. I was throwing the Frisbee for Archie Ruckus today. Maybe it was...
There you are. Okay. I moved the Wi-Fi booster down.
Maybe it was too much running around. So first I had to pick up all the dog crap. And then we were running around. He was running around with the Frisbee. Chasing it too hard. I don't know. But this is what I was doing on Locals today. It was so fun. It was so beautiful outside. He did get himself worked up into a lather, though. So I don't know. His tummy's bothering him. I don't know, but this is hilarious. So this is the kind of stuff we're doing on Locals. And I was, the hole for the chicken coop, by the way, is over here. I found it right here in the corner by the, well, I could just show you. See, you get to see the chickens too. Let's see.
Of this stuff and put it.
Looking for the holes.
I
was looking for the holes and I found one. Let's see, where do I find it? See, I got one egg, but I found a hole. Oh, there's my chickies. Aren't they pretty? They're so funny. But yeah, I found a hole way over here. There's my rooster. That's King Louie, by the way. They're so awesome. Yeah, they're good. The chicken cam. That's the next thing. I got to work on a chicken cam. Mr. Fox actually said he wanted to get a trail cam with an SD card. I really want something that I can just stream on a YouTube channel so that I don't have to deal with uploading videos. Wouldn't that be better to have a 24-hour chicken cam? I just don't think I have the bandwidth for it. But this is where the hole is. They were all digging a hole like right here, like they're trying to escape. Like, where are you going? Where are you going to go? You know what's out there, chickens? Foxes. That's what's out there. Don't break out. The chickens
introduced him to the ladies. They all pretty much fell in line except one. And she decided she wanted to fight.
There, see, I put rocks by the hole. There was a big hole right there. And I was putting some rocks down so that whatever is digging, if it was digging from the outside, won't be doing that anymore. I found a bunch more too. So it looks better than that now. Anyway, it's a constant thing. Keeping up with the chickens, they could be digging to doom. I totally don't have the bandwidth for it. I know, Linux. I don't. So we'll probably just get the SD card and upload the videos when I can. I know there's so many of those cams that get a lot of traffic, like the Eagle Nest cams and stuff. I know. I think it would be money. It would be totally money. It would be so great. Oh, yeah. Foxes. There's lots of foxes around me, and they are brutal. If a fox gets in there, they will kill all of my chickens at once. I won't have any left. They are brutal. I lost 9 in one day once, and I only have 8 chickens right now. Actually, I have 7 hens and 1 rooster. Oh, gosh. All right. That's it for me. I love you guys. Thanks for being here, and I'll see you probably tomorrow on Locals. Go to meganfox.locals.com and sign up. I'm also going to be doing, you know what we're going to do on Locals tomorrow? We're going to do an episode of the confessions on Netflix, of forced confessions that cops do to people. It's terrible. No, I'm not going to kill the chickens. I swear I'm not. They're my pets. But yeah, we're going to do one of those movie with Meg tomorrow. So stay tuned for that. If you're not a Locals member, you need to be meganfox.locals.com. And that's it for me. Love you guys. See you later.
I was so lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh. goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. This time I know my road is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna stay. No, I don't wanna say goodbye. No, I don't wanna say goodbye.
So I take it that
Johnny's
you've seen
problem is he
Cameron
should have come
John's bedroom
storming
before.
in there with
Yeah.
a string of
Do you
garlic
recall what
and
he
some
went
holy
into,
water.
Mr. Judson, as
Cross,
far as
a crucifix
bedroom
one.
May the
Do you
power of
recall,
Christ
or no, you
compel you.
No, I don't.
You
sure
realized his house
misheard.
was infested with
Except for
succubuses.
that,
And
there's a picture on here with you of what it, yes. Do you recall whether it was there
Succuloters.
when you arrived in the afternoon? I don't remember seeing it now. So while she
No wonder he said drown her before you burn her.
Oh my God.
You-
Your next witness?
Now I know
Witness
why
Your
he
Honor,
wanted
is now
to drown her.
Laces, and
Next
that is
witness
also
lives in
by
Romania.
video.
Is that correct?
That begins with Ms.